Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, friends. Hello, everyone. Happy New Year. I thought I was on time, ready to go, and I realized now the messages that I was getting asking me if I was okay was because I think I was supposed to be here a little bit ago. I think I messed up the time in my head of what time I was supposed to be here today. So if I was supposed to be here 15 minutes ago, I am sorry, but I'm here. Oh my gosh, I've missed y'all so much. Happy New Year to all my couch potatoes. You guys, I can't even tell you. I am so excited for our year together of watching trials. So hello, Kelly P. Hello, good morning to you. Our good friend Dave. I hope all is well for you. It's been so long, you guys. I hate it. But don't worry. We are going to be spending a whole lot of time together. So I can't wait. There's the lovely Buffy Bot. Good morning to you. Right, long time no see. I love it. Happy memberversary to Amos OG. By the way, happy birthday to you, Amos. I'm not going to sing the whole song because I don't sing. That's all you get. But it is the lovely Amos's birthday today. One of my besties, my partner in crime, really, Amos. So make sure you wish her a happy birthday all day. I didn't know I was late. But Buffy's messages make a whole lot more sense now. So there we go. Nope. My brain went on the fritz, Kelly. My brain went on the fritz. Don't worry. I'll be back in the habits. Yeah, my bad. It's a new year, you know? Now, you guys, you may notice we have a little bit of a different layout for this year. And we've started, so Couch Court will now be streaming live on YouTube and Twitch. That's right. Llama has infiltrated the Twitch universe. We'll see how it goes. I don't know. But we are over on Twitch as well. Look up at the top here. You can find me on Twitch at Couch Court with Llama. We're live there, so we'll be live on there and YouTube for all of our Couch Court needs. So definitely go over and follow there as well. I'll tell you what, I haven't used Twitch before, and we started using that and Kick. And I'm just going to say the chat options, way funner than YouTube. I don't understand how YouTube's chat isn't as fun as those. Because you can like reply specifically to people. You get all sorts of emojis, all sorts of fun stuff you can do over there. So go over there, follow as well. Yes, I did make the schedule. I did. Yes, I can see you over on Twitch and this is right. I was going to run this to see if they both go into one place, but we'll see when it happens. Oh, good, Kelly. I love that. Yep. See, look at that. Our Twitch comments come up there. So I'll be having the chat box open since we're in two different places with two different chats, so everybody can see where all the fun is happening. And maybe that might make sense to some of my responses. I don't know. Oh, you changed your icon picture. Bitch dust. I love that. Yes, feel free to go join. Angie's over on Twitch right now. Go over there and join her for chats if you want to. Hello, new Twitch friends. Good luck. Because we're a little crazy over here on Couch Court with Llama. So, you guys, a few things first. We are here for the sentencing of Devyn Michaels, which I will get to in just a second. But do y'all remember this trial? Let me pull this up. Sorry, I'm still working on my overlays system here. It's been a while, you guys, if you can't tell. Anyway, so yeah, we'll go over Devyn Michaels, and then we'll talk about what we're going to be doing for Couch Court because y'all better be ready to hang out every day for a long time. But I think it's going to be worth it. So in November was the trial of Nevada versus Devyn Michaels. And we weren't really quite sure what we were getting into. It sounded a little spicy to begin with, but oh boy, did it turn out to be a very bizarre trial. Definitely on my list of like, what is happening? There's a lot of those faces right from the jump. Opening statement. So allegedly, well, she's been convicted now. She was found guilty. That's why we're here for sentencing. But she was convicted for killing and beheading her former ex-boyfriend and beheading him. He's also the father of her 2 children. And we're like, okay, well, that's kind of not great. But then we learned that she had been having an affair with his son, who was significantly younger. We did the math dates, but I don't remember how old Devyn would have been when him and Devyn started getting together. I want to say like 18 or 19. And she was a grown-ass woman, okay? It was weird. It was very, very weird. Oh, hi, Tracy. Oh, my gosh. I've missed you. I hope you're doing well. I hope you're having a great new year, babes. Oh, I miss you guys so much. I keep saying that. It's just because I'm like, oh my God, it's finally time. I've been waiting so long. Anywho, so they were dating, right? But remember, she had 2 kids with the dad. Well, in, I want to say 2020, her, Devyn and Devyn got secretly married. That's right. That's right. And they didn't tell Johnathan, who's the victim in this case, victim/dad/ex-boyfriend/big daddy. And so then he ended up finding out, did not seem happy about it. And then Johnathan was going to move in with Devyn to help raise their 2 girls. Yes, this family dynamic is intense. And he didn't really seem that happy about it. And Devyn told Devyn, you got to get out. But apparently Devyn had nothing to do with this murder. She was helping Johnathan, went over to his house, his mom's house that he lives at, helped pack stuff up and came home at like 1 or 2 in the morning. And Johnathan was dead the next day, missing his head because they never found it. Now, first of all, the opening statements were wild. Do you guys remember those opening statements? You remember the defense's opening statements? Because I do. All right. So the defense's theory was that it was actually Devyn, the son/husband, who killed his dad. That was the defense's theory. And we're like, okay, all right, maybe, right? And during the defense's opening, they showed us some pictures, including a picture of Devyn's eggplant, if you will. Yeah. Yep, that was bright up on the screen for all of us to see. We're all like, oh, what? That's right. Trials are never boring. You never know what you're going to see. So right from the bat, it was a very interesting trial. Devyn ended up taking the stand. And for many of us, we were just like, this guy, like, sorry, buddy, but you seem suspicious. Okay. He couldn't remember anything. He was incredibly dodgy. And it was very bizarre, his testimony was. And so many of us, myself included, were kind of like, oh, we think maybe Devyn might have had something to do with it. I don't know. Now, Devyn was found guilty of this, but I mean, I think we all still had questions at the end of it. It was so weird. It was just the weirdest. Now, I want to show you guys something else that I found very interesting yesterday when I was looking up details for today, just to make sure that it was still happening. Because so far, we are 0-2. Well, now we're 1-3 of things we've picked to cover just in this last week. So our stats are not doing great this year of picking the right things to cover. So I was looking up news to see if anything new had come out with Devyn. And I wanted to show you guys, this is on Google. This is why we watch trials. Okay. Look at, these are only 4 articles in the last month. Now, granted, I wouldn't call them the most reliable sources. We got the Mirror, US Weekly, Patrica News, I don't even know what that is, and Daily Express US. All right. So not reputable news sources, I would say. But look at all of these headlines and how blatantly wrong they are with the story. Woman beheaded ex-husband and disposed of his head before marrying his son. Former adult film star beheaded ex-husband before she married his son. Former husband beheaded, married stepson. Terrifying story of this actress will leave you shaken. Women beheaded ex-husband and disposed of his head in the trash before marrying his son. Okay, who wants to get a gold star and say what is wrong with each of those headlines? There's 2 things wrong with them. 1, her and Johnathan were never married. No, they were never married. They had 2 kids together, but they were never married. 2, she married Devyn in 2020. This happened in 2023 or something. Her and Devyn were married long before Johnathan ever died. But it's like, this is why we watch trials, because you cannot rely on everything that's in the media about a trial. I mean, these are blatantly wrong, just wrong all over the board, So I just wanted to bring those to everyone's attention because they're like, trials? Why do you cover trials? That must be boring. First of all, no, they're hardly ever boring. Some days are boring. We definitely have had some very boring days of trials together. But also, that's where you get the facts, and crazy things happen in trials. Like, I don't think I've watched one where something just crazy and outlandish didn't happen. So I wanted to share that with you guys. And don't worry, we're still waiting on court. As you see, we don't have the seal up yet, but they are scheduled to start noon. But we all know courts can be late for everything. So we'll just leave that in the background there while we wait for that to happen. Hey, Rockstar. Oh, Kelly P., happy member anniversary for you. She says, woohoo, I have missed your lives. I've missed being live too. I've missed all of my friends. We're going to have some good times together. So while we're waiting for court to begin over there in Vegas, let's talk about what's going to be happening with Couch Court with Llama real quick, because we're going to be spending a lot of time together. So first and foremost, as I already said, we're going to be on YouTube. I think these are switched over for you guys. So I think YouTube would be this way and Twitch is the other way, or vice versa, whatever. You guys know I'm not good at pointing at things. So this week, right now, we're on both YouTube and Twitch. On Saturday, I will be starting to cover news, true crime news, and I'll be doing that live over on Twitch Saturdays at 3 p.m. Eastern. And then that will be uploaded to YouTube. I think we're doing that Monday nights or something like that. So if you want to watch the recording live, go join me on Twitch. Otherwise, the video will come out itself. I think Monday night at 7 Eastern is what we decided. I don't know. Apparently, I'm not good with schedules that I make today. And then, so we have picked out our trial, you guys, because trust me, this last, you may not have seen me, but we have been busy behind the scenes for the last month and a half-ish. All right, we were going to do Sarah Grace Patrick, but that got postponed to August 3rd. So we had to take that one off the board. And then the other ones that we're interested in, we don't know if they're even going to go or not. That would be Virginia versus Brendan Banfield, which is supposed to start next week. Arkansas versus Aaron Spencer. We don't even know if it's going to be televised, and a few others. And then it came out that there is a case that is going on right now. They're in jury selection. And that is the case of New Jersey versus Paul Caneiro. Oh, we got court open. Don't worry. The judge is not there yet. And right now they are, geez, you remember that horrible wig she was wearing the whole time? Oh, it's so bad. She does not have that on right now. Here, I will, since it's up, we can just do this so we don't miss any of the action there. Boop. Oh, I need to switch my little couch potato. Oh, I don't have it, so I can switch my couch potato. That one I didn't upload yet, but that's okay. Whatever. Oh, Court TV seems to be having some problems. Anywho, while they're sorting that out, so right now they're in jury selection for Paul Caneiro. He allegedly murdered his brother and his family, his wife and 2 children, in their New Jersey mansion home. The details are pretty horrific. Prepare to cry at least a day or two, because I looked up some of the details yesterday because I didn't really know much about it, and I was like, oh man, oh, that's heartbreaking. And allegedly,
Judge Pierre Jones presiding. Please be seated.
oh, this is real serious, guys. Are we good? Can y'all hear? I'll get back to that case in just a minute. Oh, that wig was awful. That's true. Twitch is free. They're joining us over there. Good morning, Bells. Good morning.
Mr. Brown, can you approach?
Oh, I forgot we had loud static. Okay, well, since they're talking. Anyway, so Paul allegedly murdered his brother and his family in their New Jersey mansion home. He then allegedly set the house on fire, then allegedly went back. Oh, we might be done. And set his own house on fire.
How are you here?
I'm here for Mr. Bunker. That would be page 22.
Oh, there's going to be other cases we're hearing today, guys.
Let's go to page 22. C 390495, State Route versus Jackson Bunker. Make the record reflect that Mr. Bunker is present in custody. Mr. Caneiro is here on his behalf. Mr. Pesci is here on behalf of the state. This is daytime set for the defense motion to continue the trial. That's set for January 20th, as well as county call. Mr. Pesci, have you seen the motion?
Yes, Your Honor.
What is the state's
This is
position?
weird.
All right. The motion, Mr. Bunker, sir, you understand what's happening?
Oh, yeah.
Is that a yes?
Yes, ma'am.
Mhm.
All right. All right. I'm gonna grant the motion to continue. The jury trial is gonna be vacated. Did you guys discuss when you wanted this reset?
Yes, Your Honor.
I like this. We
My
hardly ever
client
get to
is
see court
consented to
just like
continuing
happen.
it. He has some reservations about how long it might take, but I think based on Mr. Pesci's schedule and my own, September works best.
Okay, especially, anything else you wanna add?
Yes, there was some conversations about June. Unfortunately, I have 3, not unfortunately, but I had 3 set in front of you in June, so I don't think I
The
can.
Caneiro trial?
I guess I'm not going on vacation,
What was
Mr. Pesci.
I didn't set those.
All right, let's go ahead and let's set the jury trial for September 14th.
Your countercall can be September 3rd at 9 a.m.
Let's hear
Your
from
pre-trial conference is going to be August 27th at 9 a.m. And your status check trial readiness will be April 9th at 9 a.m.
Thank you, Judge.
All right,
Thank you, Your
okay,
Honor.
guys. Is that all you have, Mr. Wood?
That's right, yes.
Okay. Mr. Valente, what are you here on?
I'm on page 14, Vasquez Machado.
Okay.
This is not what I was expecting today, so.
Let's go to page 14, C 389906, David Ramos, Julio Vasquez. May the record reflect that Mr. Vasquez is present in custody. Mr. Valente is here on his behalf. Ms. Mercer is here on behalf of the state. This is daytime set for suspect trial readiness. Mr. Valente, how are you doing for June 8th?
Well, I mean, I still don't have the officer's report as well as the coroner's report, which was the basis for the continuance the last time.
Members,
I love
I
that.
believe the coroner's report is done. I thought I sent it to Mr. Delente, but I'm going to call my office when I return. The officer's report, the detective indicated she's still working on it.
Well, that is what we
Okay,
will
can
be
you-
watching.
We got to take them to let you know that that clock is ticking.
So I'm
And let me
very
know about the
excited
court.
about hearing
Yes,
your
all right, come back,
insight.
status check at 30, just to make sure those things have been handed over. That date is?
February 5th at 9 a.m.
Thank you, Your Honor.
All right, thank you, guys. All right. Mr. Martinez, what are you here on?
Your Honor, I'm here on page 6. I don't know if we have all the attorneys for the co-defendant.
I don't think we do. As soon as we do,
We have Mr. Sheets.
Mr. Sheets, I thought I saw Mr. Flayhide.
Courts can be very chaotic in the
Who
morning.
else do we need?
Maybe yes.
I know the DA is here.
Well, Mr. Martinez is here, Mr. Sheets, Mr. Flayhide. There was somebody else that was missing, Mr. Agers. We need
There's
Paul
a lot
Agers.
I
As
don't
soon
know
as he
about
gets
this,
here, I'll call you
Tracy, so
back.
I'm
Great,
very
thank you.
All
interested
right,
in
let's
it.
go to page 1, C 395678, State Battle versus Darnell Davis.
All right, you know what I'm gonna do? I'm gonna turn this.
May the record reflect Mr. Davis is present in custody. Ms. Shamley is here on his
There we go.
behalf. Somebody, anybody from the state of Nevada? Mr.
I like your
Johnson is here on
microphone's
behalf of the
working,
state.
but I turned that
Mr.
down a
Daytime
little
set for
bit.
defendant's motion to
You guys don't mind me
dismiss counsel
talking
on the
over
basis of
this,
your
right?
desire to
I mean-
continue forward with that motion?
We don't know these people.
All right, I'm gonna set this down for a young
Um,
hearing. Monday morning, January 12th at 8:30.
Well, never mind. I don't want to do that. We can cut that afterward.
Who's the defendant's name?
Darnell Davis.
Watch it. We might pick up some good trials.
I saw him earlier.
We will be. I'll be talking about Llama After Dark as well, because that's coming back. We got lots of Pouch Court news to share with all of you guys.
I don't think he's there. The seat is empty, Mr. Yu.
Or he just called me from his jail cell.
Oh, I love
They
this.
haven't transported.
Hold on just 1 second. Let me just call it so we can walk it out. All right, let's go to page 19. C 250928, State Nevada versus Julius Bradford. For the record, Mr. Bradford is not present. May the record reflect the prison appears to be online, but the chair is empty. Mr. Bradford is pro se. Mr. Ewing is here as standby counsel. Mr. Pesci is here on behalf of the state, and Ms. Corey is
look at
here
that.
on behalf of the Nevada Department of Corrections from the Attorney General's office. Mr. Ewing.
You know, I got a call 5 minutes ago from him. He hasn't been transported. Doesn't know why. He doesn't, it usually takes like an hour to get them anywhere
Right.
over there.
Ms. Corey, do you have any representations about why he hasn't been transported to the video room?
Uh-oh.
I have not, Your Honor. I haven't heard from them this morning. I can try giving them another call.
Okay, can you call them so that you can give us an update as to whether or not they're gonna get him to the video room?
Mhm.
I will do that right now. Thank you.
Okay, so, Mr. Young, we just hang out, I'll come back to you guys as soon as she comes back. All right.
Yeah,
Ms.
we did
Lower,
get one
you
that
have
we
any-
know is actually going to be televised.
Yes, Your Honor.
All right, let's go to page 16, A 873-070, Michael Rodriguez versus the state of Nevada. May the record reflect Mr. Rodriguez is not present, he's the custody of Nevada Department of Corrections. Ms. Lowe is here on his behalf, Mr. Pesci is here on behalf of the state. This is daytime set for further proceedings from the Supreme Court, so we need to set this down for an evidentiary
I forgot how
hearing in
fast it
regards
talks.
to
Did you
claims
guys
1
forget?
and
'Cause I
4. Based upon the Supreme Court order, have you guys had a discussion about when you wanted the hearing?
No,
It's like an auction.
No, we didn't, I didn't know who would be assigned to it.
it's not gonna be me.
It's not gonna be you, Mr. Pesci?
Sorry.
All right, well, I'm gonna go ahead and set the hearing, and Mr. Pesci, you guys are gonna need to figure out who this case is assigned to.
That's Mr. Forks, because he took over this record.
Okay. All right, so we're gonna need to go ahead and set it down for a hearing. Can you guys be ready on January 30th?
Anyway, let me, one moment, please.
I mean, she does not fuck around.
Yeah, I do clear that date, but I just wanted to note that, Michael Rodriguez has expressed the preference of being able to appear via video for the upcoming hearings.
Oh my gosh, what do you guys
so
think
that
of the
would
cute little
ask.
couch
But
potatoes?
yes,
Did you
the
notice that it's
30th.
animated?
For the actual evidentiary hearing or for another status?
No, for the evidentiary hearing.
Okay, yeah, that should work for me. I guess I'm a little bit, well, no, it should be all right for the witnesses too.
All right, well, we're gonna set it, and then if you guys get notification from the witnesses that they're not available, then you guys can contact Chambers and we can reset the date.
All right.
And so, does he wanna appear via video for the hearing?
He did request, right, that he be allowed to appear. He's from Lovelock and he's involved in programming and says every time he's yanked out, he has to start over or misses things. So yes, he did want to stay even for the, I said, well, you're gonna be testifying. I don't know if she'll allow that, but I'll ask.
How's he gonna confer with his attorney?
If he's okay with not conferring with his attorney, Mr. Baxter?
Preference.
So you're okay with
Right
him not
back.
being in the same room as you because you're not gonna be able to talk to him?
Right, that is a concern, so I'll discuss that with him, I guess,
Well, the problem with that, Ms. Lowe, is if you want him to appear via video, even if you want him here, the order to transport needs to be done today because the prison requires 3 weeks. So I need the order to transport today in regards to whether he's gonna be here or be on video.
I did have misgivings, on that, so let's transport him.
All right, well, I need you to submit the order today.
I do the order, does the state usually do that?
No, not on these, you can do it.
Okay,
All right, submit it today.
all right,
All right, thank you, guys.
thank you. Is that it?
Yeah, that's it. Mr. Rahman, have you had any contact with Ms. Hashmati or somebody from the public defender's office?
Your Honor, is Ms. Hawkins, she'll be here around 9:50.
Mr. Gaston, are you ready?
Sure. Mr. Sanchez, Ricky Sanchez.
Okay. Let's go to page 8. Oh, that's the sentencing, right?
Yeah.
Yeah, I'm not sure of that.
Okay, that's fine.
All right. Who's here on Watson? Are you ready?
Yes.
All right, let's go to page 18, C 395960, State of Nevada versus Lewis Watson. May the record reflect Mr. Watson is present in custody. Ms. Oliver is here on his behalf. Mr. Pesci is here on behalf of the state. This is the day and time set for our status check trial readiness. Ms. Oliver, are you on track for February 9th?
Your Honor, sure. Mr. Pesci is probably one of the best at getting discovery, so I believe fully that
Mr. Zach, did you hear that, what she said?
He gets it very, very early and it's very thorough. I forgot to check before I came. Did we have the officer's report yet or
I
no?
don't believe so.
So there are still things, obviously they're outstanding just because of the nature of the case.
Right.
We're continuing to try to investigate some
Sorry,
things that.
he went to go get more coffee.
Mr. Watson has pointed out to us, so I can do what I can do.
Right.
So far, so
You're
good.
playing with all the emojis over there on
But
Twitch.
Mr. Watson wants his
Fine.
contract.
I get it, all right? So right now, I'm gonna leave the dates as they are, and I'll see you guys back here for your pre-trial on the 22nd,
Thank you.
okay? Is somebody here from Mr. Becker's office? Mr. Patrick, you ready?
Yes, ma'am.
Let's go to page 21, C 385494-4, State of Nevada versus William Hill. May the record reflect that Mr. Hill is present in custody. Mr. Patrick is here on his behalf. Mr. Palal is here on behalf of the state. This is on for the state's motion as well as the statute EMP. What happened to the new case?
So Judge, the new case was dismissed as expected on Tuesday. I'm sure the court read the police report.
I did.
Mr. Palal read the police report. Chatting with Mr. Palal yesterday.
The new
I'm
coffee
gonna
maker
ask that
is
Mr. Hill
amazing.
be released today on the original bond and house arrest. And I believe Mr. Palal is gonna have no objection.
I would say that if you read the police report, you would also realize that the defendant admitted to having an extra phone that he was hiding from the house arrest officer, which I think is probably less than the behavior one would expect for somebody who got a $100,000 bail on a murder that's on video. So that I would suggest that maybe a little less glibness would be appropriate given the
Yeah,
circumstances here.
$100,000 bail
That being said, I'll
on
submit to the
video
court
for murder.
regarding the defendant's custodial status.
Okay, hold on. This one. All right, so Mr. Hill, you understand
True.
the concerns based on what Mr. Palal stated. You're not allowed to hide phones from the house arrest officer. Do you understand that? All right, you understand this court doesn't tolerate new cases under any circumstances. So I'm gonna reinstate your original release conditions because that new case was dismissed. All right, so today you're gonna be released back on house arrest with the previous bond already having been posted.
Thank you, Your Honor.
Thank you.
So he just goes about his day on house arrest. Okay.
All right, is anybody here on the fields?
That's my case, this is Mr. O'Brien.
Okay. Ms. Stanley, can you find out where Mr. O'Brien is?
Okay.
From our office,
Miss
yes,
Fanny.
he's actually out sick today. I just got a text from him.
Okay.
So I'll figure out what's going on.
Okay. Mr. Helmut, you ready?
Yes, ma'am.
Let's go to page 2, C 395950, State Nevada versus Tyler Johns. Mr. Johns is present
like
in
it has the
custody.
pause
Mr.
side, but
Helmut
then
is
it
here
has
on
a
his
pause
behalf.
side as well.
Mr. Jackson is here on behalf of the state.
I've
This is
actually
the
had
date
it
and
for
time
like
set for continued arraignment. State
several
I do not
years.
see a notice filed as of this morning. Is this
We are
normal?
not taking that.
Okay, in light of that, Mr. Helmut, are you prepared to go forward with the arraignment?
Yeah.
All right, Mr. Johns, sir, what is your full name?
Tyler Matthew Johns,
How old are you?
22 years old,
How far did you go in school?
high school now.
Do you read, write, and understand the English language?
Yes, ma'am.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No, Your Honor.
Do you understand the proceedings that are happening here today?
Yes, Your Honor.
Sir, are you familiar with the 3 charges that you're facing?
Yes, Your Honor.
Do you understand those charges?
Yes, Your Honor.
As to those charges, how do you plead, guilty or not guilty?
Not guilty, Your Honor.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
I'd like to waive that right, Your Honor.
Okay? This case is gonna be assigned to Department 6. This case is gonna have a status check trial setting in Department 6. That date is?
January 13th at 9:30.
Okay, thank you, Your Honor.
All right, thank you guys.
Thank you, Your Honor.
So we're still waiting for Mr. Ages.
Ken Cozell is going to be here for him, Your Honor.
Oh, yes. Can one of you reach out to him and find out where he is?
And that's an arraignment. It's literally all there is. So for that.
Mr. Jackson, can you approach on another way now?
Yes, sir.
Ugh, gross. I hate that noise. Somewhere. Haven't. Sorry, I gotta send a message. Oh, what was I gonna say? Oh, so while we're on a break here. So I wasn't expecting to have like a full court today. Usually sentencings are just like reserved for the person being sentenced, but apparently.
Yes, Your Honor, thank you. I just got off the phone with the institution. Mr. Bradford refused his transport up to operations to attend this court hearing today. They are getting him to sign a document stating as such, and if he refuses, I will have a declaration from the search and escort team about his refusal.
Okay, I get that. So we're back on the record at C250928. So based upon those representations, what I'm gonna do is I'm gonna set this down in a status check in 60 days. If you could submit those documents to the court, and if they have documentation that he refused transport to the hearing today, the court is gonna rule on the pleadings and just issue a written decision.
Yes, Your Honor, I will get that submitted as soon as possible.
Okay.
March 12th at 9 a.m.
Thanks, Judge.
Thank you.
Thank you.
Thank you, Mr. Newman.
Okay. Oh,
Your Honor?
Yes. Just 1 second.
Oh, no rush.
I wonder if anyone's even doing victim impact statements. I doubt Devier is. Oh yeah, remember Devyn was also married to that Robert guy from the Monica Simonelli trial that killed her husband, Fabio. Was Devyn's ex-husband.
Let's go on pages 3, 4, 5, and
ex-husband.
6. C396273-1, State Nevada versus Sharnae Hopkins. Make the record reflect that Ms. Hopkins is present in custody. Mr. Fayad is here on her behalf. State Nevada versus Devyn Jackson. Make the record reflect that Mr. Jackson is present in custody. Mr. Kozol is here on behalf of Mr. Adris.
Oh.
State of Nevada versus Dora Williams. May the record reflect that Ms. Williams is present in custody. Mr. Sheets is here on her
right
behalf.
over on Twitch.
State of Nevada versus Dwight Delancey. May the record reflect that Mr. Delancey is present in custody. Mr. Martinez is here on his behalf. Mr. DiGiacomo and Ms. Anderson are here on behalf of the state. This is the date and time set for arraignment. Are you guys prepared to go forward with the arraignment?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right, we're gonna take them in order, so let's start with you, Ms. Hopkins. Ma'am, what is your full name?
Sherman Cheryl Hopkins,
How old are you?
33.
How far did you go to school?
Some college.
Do you read, write, and understand the English language?
Yes, ma'am.
Ma'am, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No, ma'am.
Do you understand the proceedings that are happening here today?
Yes, ma'am.
Ma'am, are you familiar with the 2 charges that you're facing?
Yes, ma'am.
Do you understand those charges?
Yes, ma'am.
As to those charges, how do you plead, guilty or not guilty?
Not guilty.
Ma'am, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
I was
Would like
hoping
to
to see
invoke,
the
Your Honor.
charges.
Okay. All right, let's go to Mr. Jackson. Mr. Jackson, sir, what is your full name?
Devyn Michaels,
How old are you?
37.
How far did you go to school?
I didn't get past the struggle. I was small, first grade, sixth grade. Sixth grade.
6th grade. Do you read, write, and understand the English language?
Little, yeah.
Somewhat. Is that a yes?
Yes, yes.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
Medication.
Does that medication in any way affect your ability to understand the proceedings that are happening here today?
No.
You understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the 2 charges that you're facing?
Yes, ma'am.
Do you understand those charges?
Yes.
As
I
to those
don't.
charges,
Can
how
you
do
tell us
plead,
what they are?
guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
I'm gonna vote.
Okay. All right, let's go to Ms. Williams. Ms. Williams, ma'am? What is your full name?
George Siobhan Williams,
How old are you?
33.
How far did you go to school?
Junior high school.
Okay, do you read, write, and understand the English language?
Yes.
Ma'am, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here
Isn't
today?
he adorable?
Ma'am, are you familiar with the 2 charges that you're facing?
I've named him
Do you
Poe.
understand those charges?
Yes.
Or
As to
Poe.
those charges, how do you plead, guilty or not guilty?
Not guilty.
Ma'am, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Involved.
Okay? All right, let's go to Mr. Delancey, sir.
He's
Sir,
my new
what is your full name?
on-screen friend.
How
I
old are
don't
you?
feel so lonely.
How far did you go to school? Do you read, write, and understand the English language? Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the 2 charges that you're facing? Do you understand those charges? After those charges, how do you plead, guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Waive.
Okay?
I don't think you're supposed to waive
This
your right
case
to
is going to be
a
assigned
trial.
to Department 12.
Not at first.
This case is going to have a status check trial setting in Department 12. That date is,
Not at first.
January 15th.
I wouldn't anyway.
all right?
Judge, can I have you call Mr.
Thank you, Your Honor.
Yes.
and
12.
the co-defendant, Ms. Lopez?
Like, I was always under the impression that you don't waive the right right away.
Daniel Roush.
Put the pressure on the state.
Gina Lopez.
Otherwise, they'll dick you around for however many years they want to.
Mr. Horvath here on his behalf. May the record reflect Ms. Lopez is present in custody. Ms. McNeil is not present. Mr. DeJacmo is here on behalf of the state. Mr. DeJacmo?
Yes, Ms. McNeil reached out to me. She's in Elko. She asked me to make representations as she anticipates being ready
Okay.
for the current trial date and would ask that her presence be waived for this particular proceeding.
Okay. Mr. Horvath, anything, are you on track as well?
Yes, Your Honor.
Okay. Staying on track?
That's because you're
Yes.
super
Okay.
special.
Sound check at 90.
Ines.
The April 9th at 9 a.m.
All right. Thank you, guys.
I baked her a virtual birthday cake and everything. Oh, we're muted again. Okay. That's good. At least they caught the static this time. Or actually, it looks like it froze. Oh, I hope it stay frozen, not me. Oh. Okay. So it was definitely a them thing. Hold on. They might come back in the meantime. Or they're probably just like, it will just come back when it's time. I was going to say, I don't remember there being a lot of issues with this trial except for Javier's audio. Oh, that microphone. couldn't understand anything he was saying ever. Not that he was saying much of anything. But anyhow, all right, well, we're waiting for this to come back. Did we kill it? I think so. I think so. Oh, man. Well, I wasn't expecting all these arraignments and everything wrapped into one. That's pretty crazy. But yes, she does have the hair like she has in that picture. Today, it's a little bit longer. She does not have on that atrocious wig that none of us can believe her defense attorneys allowed her to have on, because it was so bad and crazy looking that it definitely made her look more guilty than not. It made her look fucking nuts and like she would in fact cut somebody's head off. So that was a bad choice to have her wearing that. No, she does not have that awful wig on today, at least not when they showed her earlier. So she's off on another side of the courtroom, like kind of, we see all the inmates over here, but she's on the other side. I don't know if that's because she's a female prisoner or because she goes on later or what. Oh, maybe, that's a good point, Kelly. Kelly says, who knows? Maybe they told her and she refused. Could be. Oof. It was a bad choice.
The motion to continue is devoid of any specifics. It doesn't say what investigation they need to do. It doesn't have any mention of what discovery they just received or when they received it or why they don't have time to review it by trial. It doesn't talk about what preparations need to do. Their case seems relatively simple. It doesn't explain any due diligence that was done in the last 8 months as to why they couldn't have been ready for this trial date. It just mentions that their client's out of custody, so of course has no problem continuing the trial. Well, my client is not out of custody. My client's been in custody this entire time and wants his trial date. There's very little evidence tying him to the homicide. He wants to go to trial. So I'm objecting to the motion to continue. If the court is going to grant their continuance, I would ask for a quick reset. And also, there's a Nevada Court of Appeals case, I think it's called Chittenden, which talked about how courts are to consider a defendant's custody status when granting or not granting a motion to continue. My client's been in custody this whole time. I think when he was originally charged, he had a parole hold, so his bail was never actually addressed. So he's never had a bail set. So if you are going to grant the continuance, we definitely want to address the client's custody status, my client's custody status, so that he gets a chance to get out of custody as well. It just seems off the top of my head a little silly that the co-defendant who confessed to the murder and said that they did it alone has been out of custody this whole time, and my client, who has very little evidence tying to him, has been in jail this entire time. So we either want to go to trial on the date that is currently set and contest the charges, or if it's getting continued, we want his custody status to be set on something that actually gives him a chance to get out of custody.
Well, Mr. Gusson, I understand all the points you made, but I want you to know I'm not sua sponte considering anybody's custody. So that issue has never been raised with this court, so it's never been considered in regards to your crime.
Happy New Year. I've missed your face.
All right, Ms. Levy, anything you want to add to?
Well, Your Honor, and I haven't been on this case for 8 months. Yeah, so I was appointed right before the last trial setting, and it was continued till this setting, which I said I don't believe that's enough time. It was like 3 months or so for me to get ready over the holidays. There's absolutely no way I would be ready, and I told the court when it was set that I wouldn't be ready for this trial setting. I didn't receive discovery until after that, which is a large amount of discovery, multiple cell phone dumps, and I haven't had a chance to review everything. So there's absolutely no way I would prepare to go forward. Additionally, as this court is aware, I know the co-defendant's counsel is asking for a short set. This court knows that I start a 3-month federal trial on March 23rd in front of Judge Navarro.
What day?
March 23rd.
3-month federal
So
trial.
I will not be ready to go before then. I'll be preparing for that. That's a 3-month 11 homicide case in federal court. So I'd ask the court to continue. I mean, I'm obviously not going to be ready. So.
Yeah. Ms. Caneiro, what's the state's position on the motion to continue?
I have no opposition, and just in Ms. Levy's defense, there is quite a bit of discovery in this case, so I'm not surprised by her motion at all.
Okay. Well, I mean, Ms. Levy did indicate, and Ms. Jackson, I know that you were not on this case at that time either, so you weren't here. Ms. Levy did indicate to us when this was set that she could not be ready to go. This date was likely not viable, but she would be working to get ready, as well as if the discovery she doesn't have, she doesn't know what it is that she doesn't have, as well as I've indicated in the motions and everything you filed, there were still things coming in and there were things that were being filed. I know I still owe you a decision on the motion to suppress because these things happened in the last batch of discovery and you filed the motion as quick as you could. So I understand. The January 15th date for the motion to continue and the calendar call, you indicated it? The jury trial will be vacated, but I do understand where the defense of Mr. Smith is coming from. And based on the several motions that Mr. Doss has filed in this case, I'm aware of the facts of this case. So I do believe that I understand where you're coming from in regards to wanting to consider your client's custody status. However, pursuant to the court rules, you have to do that in writing. And as I stated, this court has never been asked to consider your client's custody status, so I never considered it. You guys can file a motion, but what I am gonna do is set this on for a status check, because what we do with the trial date will determine what I do with the motion on your client's custody status. So do you think you can get it filed in a week?
We can file it by the end of the day, probably.
Okay, so you want to set it next, or the other one? I can set it next Wednesday for you guys at 8:30, or I can set it, but it has to be at 8:30 because I have to sit down and now, or I can
I
set it
usually
next
don't catch
Thursday.
Jolene live, but I've definitely been watching
Either day,
Jolene
whatever
live
works for the court.
on my
Okay,
TV.
let's just set it next Thursday at 9.
And I'm like, oh my God, I know her.
And it'll be set a status check trial setting in regards to Ms. Seniceros, and the status check trial setting and a bail motion in regards to Mr. Smith.
The only other issue to bring up today, so we've been requesting, so there's a lot of cell phone stuff and location data and stuff like that. We've retained an expert to kind of independently review and verify sort of things, statements. In doing the cell site mapping, our expert indicated that they need the cell site list, the primer. You can only get that really from the detective.
I watch a lot of
Mr. also reached out to the DA a couple different times. I think the DA, no problem with the DA. The DA's explained that she would try to get that for us. She's reached out to the detective a couple times. But my understanding is the detective just hasn't gotten back to her, hasn't given her the cell site list, the primer that our expert needs. So we just wanted to bring it up that we're having this kind of discovery related issue and see if we could get a court order that the detective provide that to the DA to give to us.
Well, I mean, I'm not gonna order the detective to provide it to the DA's office. I'm gonna ask Ms. Caneiro to reach out, and if you think the court needs to intervene in getting that for you, then the court will intervene.
Understood, and I will represent that he recently, within the last few days, reached out to me. I just need to get on the phone with him now.
Okay, so you reach out to him, and if that's an issue, then I'll intervene.
The only other discovery related issue that Mr. Costa mentioned was we've requested the complete DNA file as well. There's a part of it evidence in the case that allegedly has our client's DNA on it. We want the whole DNA file to be able to give to. We've reached out to the DA. I don't know if there's an issue with
had a
that.
dog named
We
Lady.
just got it, like
Lady.
yesterday.
Great.
She was
Okay,
legal
so
like
that's
70.
it. All right, and if there's something else, you guys can bring it up when we come back next week. Okay, and I promise you will have a decision on next week on motion, I swear. You're like, yeah, Judge, I heard that before, but I promise this time. So before I see you next week.
We know you've been busy and
Yeah.
we've all been busy as well.
Thank you guys.
Thank you, Your Honor.
Now let's get to
Let's go to
Devyn.
page 15, C 391028, State Nevada versus Salvador Delgadillo. Let the record reflect the party, Mr. Delgadillo is present in custody. Ms. Jackson is not present. Ms. Flake is also not present. This is their case together. They have been reaching out to my staff to reset the hearing in regards to the discovery motion. So we're going to continue this until that date. Okay, because I'm pretty sure they thought this date was vacated. That's why they're not here. So this will be continued to March 5th.
Your Honor, the attorney for Fields is here.
Who?
For Fields.
Okay.
Have any name leg? Not yet, but next time we get a pet, I'll put that on the suggested. Hey, look at those fun stickers you guys gotta use, emojis and stuff you gotta use.
Mr. Rob, you had any contact with Mr. Becker's office on rights?
I talked to Mr. Solinger, and he said he expected Mr. Goodwin to cover for him.
Okay, well, she's not custody, so we come back to it. Let's go to page 23. C 396529, State of Nevada versus Levi Fields. May the record reflect that Mr. Fields is present in custody. Counsel, can we have your appearance for the record?
Of course, Your Honor. Shaylin Dieter on behalf of Mr. Fields, bar number 16521.
All right, and Ms. Willing is here on behalf of the state. This is the date time set for initial arraignment. Counsel, are you prepared to go forward with the arraignment?
Your Honor, we are.
All right, Mr. Fields, sir, what is your full name?
Levi Christopher Fields.
That's what we thought about Justin Burns sitting.
How far did you go to school?
That whole freaking day.
Do you read, write, and understand the English language?
Yes.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No.
Do you understand the proceedings that are happening here today?
Yes.
Sir, are you familiar with the 3 charges that you're facing?
Yes.
Do you understand those charges?
Yes.
After those charges, how do you plead? Guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Invoke.
Okay? This case is going to be assigned to Department 2.
Again,
This case is
Liz,
going to have a status check trial setting
so
in Department 2.
happy to have you join as a YouTube member.
All right, thank you
Happy to
guys.
have you again there. For those on Twitch, you can become members over on our YouTube channel. That's the equivalent of it's the equivalent of subs on Twitch. It's very confusing that they call them subs. But thank you for your support. I appreciate it.
Yeah, she's on her way. Okay, as soon as she gets here, I'll
Moving them on out. Oh, so the males went first. Oh, is it just Devyn's turn? I think so. Where's she going?
Mr. Below, can you approach on an unrelated matter?
What? What the hell just happened? Is that, we didn't even hear anything. She just walked out with all the other inmates. What was that about? I don't know. Maybe she'll come back out again. I guess we'll see. I mean, we did not hear her, right? I mean, I know this judge talks real fast for us, but there was no, I don't think it's lunch. It's only 9:30 their time, 9:30 in the morning their time. So I don't think it's lunch. I don't know what just happened. All right, well, we'll just keep it open and see if maybe she comes back. I don't know. Of course, this would happen to us. So this makes us like a 0.5 and 3 so far for the new year of successful court coverings. Yay, yay. Unless they did her when the feed blacked out or whatever, but surely not. Surely not, right? I don't know. I've never seen a sentencing. I mean, I've seen other like Zoom courts, right, where the sentencing does take place while all these other cases are happening. But usually one that's went to trial, it's usually just them there. So family can make impact statements, all of that. So it's very weird to see it done this way, but I don't know. They didn't kill the stream. No, they didn't. That also doesn't mean anything because maybe they don't know either. I don't know. Well, anyhow, while we're waiting to see what happens there, back to the trial we plan on covering starting next week, hopefully Monday, but we don't know. It is New Jersey versus Paul Caneiro. You can go ahead and start looking it up if you want to, but I suggest maybe just not knowing a whole lot about it. That's what I'm going to do anyway. I know the very basics, but I'm not diving too much. Again, he allegedly murdered his brother and his family, his wife and 2 children, in their New Jersey mansion home, allegedly set the house on fire afterwards, then allegedly popped over to his house and set that on fire to make it seem like somebody was targeted. This is the prosecution's theory, to make it seem like the brothers were targeted. He's also allegedly embezzled a bunch of money from their family trust because the brothers were in business together. It has a little bit of everything. I think one of the exciting testimonies I'm excited about anyway, because I haven't seen it actually in a trial that I've watched anyway. I know it happens in trials, just none I've watched, is the arson testimony. So I'm very interested to see that testified about, because honestly, I don't know much about it. So that's pretty interesting. I don't know if there's victim impact statements. They haven't done anything for her at all, even after the last one. So I'm not sure. Don't kill my dreams. And apparently P. Lola's mom is from the area. So that's really, I love that. So you can help us with some insight in the area. I like when our viewers are there. Well, I mean, granted, we may not agree on some things. I don't know. We'll see. But that's crazy. I didn't know that it was going to be that close to you, Piola's mom. So anyway, they are in jury selection right now. I believe they called potentially 2,000 jurors for this case. It's a very big deal. It gives me some Murdaugh vibes. So maybe it's the Murdaugh case of New Jersey. I don't know. I'm sure there will be plenty of characters. Anyway, you guys, it's a 10-week trial. Yes, 10 weeks. We get to be together every day, Monday through Friday, for the New Jersey versus Paul Caneiro. So it's going to be a long one, but I think it's going to be very, very interesting because this happened in 2018. I think it's 2018. It was before 2020. I think it was 2018, maybe 2017. And it's just now going to trial. So I think it's going to be very interesting. Again, you can look up stuff or you can go in kind of blind. I'm kind of blind. I only know the basics so I can talk about it. But what they're going to bring up in court, who knows? Who knows how it's going to be? And it's New Jersey. So I don't think I've watched a case, a trial from New Jersey. So that's a new state, at least for Couch Court with Llama. We have not been to New Jersey yet. So pack your bags because we're going to Jersey. Oh, I wonder if Lainey knows that. I'll have to tell her. She'll be like, oh my God. And yes, that's right. Buffy may actually join me on the stream for the trial, as well as some of our other staff members. That's right. You're going to see more than just me, hopefully, covering the trial. So opening statements are scheduled as early as next Monday, the 12th. So we could start opening statements on Monday. It could go later, be pushed to a different day if they haven't selected jurors. We'll know more come Friday. So whenever opening statements start is when we're going to start that trial. So if you are on YouTube, make sure you subscribe, hit the notification bell so you don't miss when we go live for court, because I don't think you're going to want to miss this trial. I think it's going to be long, but I think it's going to be a very, very interesting one. And then if you're over on Twitch, give us a follow so you can get alerts of when we go live over there as well. So I'm very, very excited. Liz says, I'll be cooking dinner while you guys have your coffee every morning for 10 weeks. Yes, that's right. I know. We took off for the holidays. It's been a long 2 months. Oh, they might have cut this. I don't know. And now you're going to be like, oh my God, Llama, we're going to be on week 6. And you're going to be like, I am so tired of hearing her. No, I'm coming back strong, you guys. Coming back strong. The party is here. Our lovely friend, Raindrops and Feathers. So happy to see you, babe. Hope you're doing well. Saw your pictures. Those look great, by the way. Oh my gosh. I hope you win your contest that you're in. But yeah, so that's what we're going to be doing next for us. Lady in Gray says 10 weeks. That's a lot of experts in tech evidence to me, probably in financials, because it sounds like the motive that the state is saying the motive is financials, because he didn't want to be outed for apparently embezzling money and stuff like that, which is a common motive. So I do expect there to be a lot of talk about financials. Yay. I know. I've missed you guys too. I missed you guys too. So happy we all get to be together again. What's their thing say at the bottom here? Commentary. It still says coming up sentencing. Hold on, let's pop open the chat and see if their chat says anything about what's going on. Shall we? Sometimes Court TV says things. They don't even have their chat open. That's weird. That's very weird. It was there earlier. Or is my computer just being silly? It could be just my computer going silly. Uh-oh. I think it is. Uh-oh, I broke it. And that's weird. Why won't it let me scroll down? Well, we'll just see. Anywho, so we'll be doing that live Monday through Friday. I think court probably starts around like 9. So yeah, it's going to be early mornings for us. We'll know more about that court schedule once it starts. And so then I was telling you guys earlier that there were some other trials that we were looking into covering, but we weren't sure what they're going to happen, if they're going to be streamed, yada, yada, yada. And that's Virginia versus Brendan Banfield, which is going to be a very spicy trial. If you're not familiar with that story. Arkansas versus Aaron Spencer and some others. What we're going to do with those probably, because this, the New Jersey versus Paul Caneiro. Here, I'm going to make myself big until we know what is going on over there. That we're going to bring back Llama After Dark, Couch Court with Llama After Dark. There'll be pre-recordeds that just fills in what happened that day in court, since we'll be busy with Paul. Now, they said Paul's trial is supposed to be 10 weeks. It could be less than that. So I don't know. I don't know. But those trials we talked about, if they do go, we'll do them after dark. So you'll have a video drop the next day telling you what happened, what all happened in court. I'm going to be a very busy lady for a few days. How much time did she get? Well, that is a great question, because we don't know. We don't know. We don't know what's going on. They had people in there for arraignments. Then she left the courtroom with all of them. So I don't really know. Let's see if any news has come out. Hopefully accurate news. No. Hey, to any of my moms to have X. You want to see if X says anything about this? Yeah, we don't know what she's got. I don't remember if this is a mandatory life. Oops, sorry. I don't know why it's doing that, you guys. Oh, you can't see it anyway. It's fine. It's just me. Let's do. Very confused. So I'm live. Let's go back to Court TV. See what they say. Okay. And now their chat's up. Okay. Maybe up to an hour or more before court gets to Devyn Michaels' sentencing. Mother. Cool. That's what Court TV pinned to their chat. That's what Court TV is saying. Maybe up to an hour or more before court gets to Devyn Michaels' sentencing. I knew it. I knew it. I knew it. I knew this was going to turn into an all-day thing. Okay, well, great. That's okay. We're going to hang out anyway. That's fine. What do I have to talk about? I don't know, because I was not prepared to be on all day. So I guess we can just like hang out while we wait. Let's see. I talked about the Paul Caneiro trial. I talked about my After Darks. I will be bringing a weekly news. That'll be live on Twitch at 3 p.m. Eastern on Saturdays, and then it'll drop as a pre-record on YouTube on Mondays. Let's see. We can talk about Paul Caneiro. Okay. I will read the article I found last night to give you all just a little bit of background. And remember, this is pre-trial stuff. We don't know. We don't know until we hear the evidence. As I mentioned early in the stream, you can't always rely on news. All right, so let's do this. We can do that. Share this tab instead. Don't worry, I got the court up, so if they come back. Move this one over here. There we go. Skip this ad. Stupid ads. I hate them. All right. Let's do that way. All right. So let's learn a little bit about Paul Caneiro. This is all I'm going to learn about this case. I don't plan on going down rabbit holes between now and then. So we can get the evidence from trial like we normally do. That's true. We should know that from the Karen Reed trial because the media had her convicted already, right? And wasn't great. Wasn't great. You graduate in March with your degree in Homeland Security. Oh my gosh, babe, that's in no time at all. I'm so excited for you. Oh my gosh, we've been graduating with your degree, getting married. 2026 is going to be your year. I'm glad it's going to be somebody's year. Bye, Dave. We will see you lots next week, I hope. So, yay. All right, let's talk about Paul Caneiro. While we wait to figure out what is going on with Devyn's thing. So, all right. So a New Jersey man accused of killing his brother and his family before setting their Monmouth County house on fire is finally facing trial. Paul Caneiro was dealt a string of criminal charges, including 4 counts of first-degree murder for the family massacre at a sprawling Colts Neck home more than 7 years ago. Keith Caneiro's body was discovered on the front lawn by a landscaper 2 days before Thanksgiving in 2018. The bodies of Caneiro's 45-year-old wife, Jennifer, and 2 children, 11-year-old Jesse and 8-year-old Sophia, were recovered from the wreckage. Paul Caneiro was also accused of setting his own Ocean Township home on fire while his own family was inside. Yeah, you guys. 2 fires. Not great. The trial has been held up for years as Paul Caneiro's rotating defense attorneys have filed repeated motions. He has maintained his innocence. Here is a roundup of the harrowing deaths and what we know so far about the case. And that's the picture of the home of Keith Caneiro, the home where the family was murdered and set on fire. So that is a big house. It's a beautiful house. All right. So Keith Caneiro, the brother, all right, 50, was shot 4 times in the head and once in the torso before his lifeless body was recovered from his front lawn in Colts Neck, which is very interesting. How come he was already outside and the others were inside? Like, what happened? I can't wait to hear what they believe the timeline of events was, because you'll see. So he was found outside in his front lawn. His wife was shot in the head and stabbed in the torso. Her body found near the stairs to the basement. Their 11-year-old son was found in the kitchen, stabbed in the torso and arm, according to a 2019 lawsuit filed by, I don't know how this guy says his name, so I apologize, Valasis Cardius? I don't know, but that's Jennifer Caneiro's father. According to the lawsuit, based on medical examiner's findings, the youngest victim, Sophia, who was, 8 is what they said, I think, was the last to die and was still alive while the house was engulfed in flames, leading to lung damage and smoke inhalation that factored into her death. She was found on the stairs leading to the 2nd floor with stab wounds. The autopsy suggests that she suffered before she died based on an increase in white blood cells. Y'all, I'm just going to let you know now, I'm going to cry a lot probably during this trial. I don't usually do kid trials. This isn't just a kid, obviously, but I feel like there's going to be some days of testimony that are going to be very hard for us to get through. Quote, Sophia survived her parents, albeit with multiple stab wounds for an unimaginable period of time, but demonstrably long enough to experience breathing difficulty and onset of high-degree stress, the lawsuit says. Curtis's suit has been stayed for several years pending the outcome of the criminal trial. That's Paul. That's a picture of Paul, the guy that's on trial. So Keith Caneiro started an IT consulting firm in 1989 and brought in his older brother with a 10% ownership interest. According to the 2019 lawsuit filed by Curtis, which also says the brothers took over a pest control company in 2011. Attributing statements and messages shared with attorneys, the lawsuit said Keith and Jennifer Caneiro had accused Paul Caneiro of stealing tens of thousands of dollars from them and the business that the brothers held. The night before he was killed, Keith Caneiro forwarded a company email stating that Paul Caneiro would no longer be paid his $225,000 salary, citing money missing from the business accounts, according to the lawsuit. The litigation is on hold pending this criminal trial. In separate emails and messages cited by the lawsuit, Keith had said he was working to sell his companies and pursue a new position in order to be done dealing with his older brother. About 8 months before his brutal death, Jennifer Caneiro told her sister that her brother-in-law that Caneiro had stolen thousands intended for her children's trust and education funds, some of which he deposited into his own children's education funds or used to pay down student loans. The lawsuit also said that the Caneiros had voiced concerns to other family and friends about Paul Caneiro charging excessive and improper personal expenses to credit cards held by the businesses that he worked at with his brother. Oh, look, there's chopper footage of the fire. The Colts Neck fire was reported around 1:30 p.m. on November 20th, 2018 on Willowbrook Road. Investigators have said they believe Caneiro first killed his relatives and set the fire in Colts Neck before returning to his home about 5 a.m. Prosecutors said the fire at Caneiro's house was both a ruse and an effort to destroy evidence that he had taken from the Colts Neck scene. CBS New York shared helicopter footage of Colts Neck fires. It was still being put out in 2018 as posted on YouTube. The once $1 million property was cleared of the burned-out wreck by a demolition crew in 2020. Paul Caneiro started with a public defender before using several prominent defense attorneys in the following years. In February 2025, Monica Mastielone took over as defense attorney. I don't know if that's how you say her last name. We'll learn more when the trial starts. In December 2018, the Monmouth County Prosecutor's Office had already said that a trial might not get underway until 2020. That was before the COVID-19 pandemic wreaked havoc on all court proceedings. The state Supreme Court agreed in September to hear prosecutors' appeal on one of the Superior Court Judge Mark Lemieux, rulings on evidence in the case. Excuse me. Pushing jury selection to this month. Last month, the state Supreme Court ruled that prosecutors can use a digital video recorder as evidence in Caneiro's trial, despite it being taken without a warrant issue. Interesting. 7 years ago, CBS New York shared video of Caneiro's first court appearance. Oh, interesting. So that's just a brief overview of what that trial is going to be about. Yeah, it's there's going to be some sad days for sure. So it's going to be tough. Sweet little Sophia's, the testimony for her, I know is going to be really, really hard to hear, because I didn't know that either until I read this article last night, and I was like, oh shit, what did we just set ourselves up for? But anywho, so that's the trial we're covering next. That's going to start sometime next week. let me see. I'm trying. It's Court TV's put some stuff up in their chat. Let's just a second. We'll go back to Paul. Paul Hickson saying, "What is? We will not know until a little later after show meeting." Oh, they were asking about Vinny's show tonight, so that has nothing to do with the sentencing. So, so I know that they're saying that. I think they're saying the murders occurred between like 1 and 5 in the morning or sometime in the early morning hours. But why was the family scattered all around the house? I don't think a 10-year-old or 11-year-old and an 8-year-old would be up at 1 in the morning in different parts of the house. Like, I wonder what that's about. I don't know. Oh, apparently they found her blood on his jeans in his home. I mean, I don't know. Again, let's keep an open mind. We've seen states say things that don't end up being true at all. But, I mean, so far this guy, it's not looking good for him. Let's just put it this way. Not looking good for Paul here already. The defense is going to have quite a few hurdles to jump, especially if all that missing money. Oof. So that's why I said it reminds me a little bit of the Murdaugh trial, because I believe they're a fairly prominent family in the community, I think. I'm not super familiar. Jesus Christ, Paul. I can't wait for you to do that when we're doing footage. And then Mr. Buffy come around the corner being like, what did I do? So I think it's going to be lots and lots and lots of testimony. I mean, you got 2 crime scenes, 2 bouts of arson, deaths, medical examiners for those. Oh, it's going to be something. Plus all the financial stuff. I don't know. So I do have lots of questions already, but we will see what else they have to say. I'm sure our New Jersey friends know a lot more about the case, and we definitely will be interested to hear all of your local insights into that. But that's what we'll be doing there. So I guess we got time. I guess we could, let's see what these, let's see what does this do? Let's see what this does. Oh, it's 15 minutes. Oh, we could watch his first court appearance. You guys want to do that? Let's do that. We got time to kill. Why not? Give us a good idea of what we're looking at. Maybe hear how to pronounce some people's names. All right, let's give this a go since we got time. Hopefully the audio is not too bad. It's not great. Those are interesting jail clothes with all those buttons. Oh, I'm probably going to have to use the booster for this, aren't I? There we go. We might as well. Let's zoom and see. Oh, I like that lady's dress. I love me some polka dots. Okay. Oh, this isn't even the normal courtroom.
All right, this is the case of the state of New Jersey versus Paul Caneiro, dockets W2018581304 and W2018790137. All right, your appearances, please.
Good morning, Your Honor. Chris Decker, Assistant Llama County Prosecutor for the state.
Good morning, Your Honor. Mitchell Ansell, Grimmett Aaron, Paul Caneiro.
Good morning, Your Honor. Robert A. Honecker Jr. from the firm Ansell, Grimmett Aaron on behalf of Paul Caneiro. Thank you. All right, thank you. Very good. We will begin with a reading of the defendant's rights. Mr. Caneiro, you're here today because you have been charged with an indictable or disorderly persons offense. This opening statement is designed to inform you of your rights and the procedures for today. Please listen carefully. I will begin with a reading of your rights. You have the right to remain silent. Any statement you may make may be used against you. You're being represented by a private attorney today. If that should change and you ever want to make application for public defender, you have the right to do so. If you are not a United States citizen and if you plead guilty to or are convicted of certain offenses, including some motor vehicle offenses, it may result in your being deported from the United States, or it may prevent you from being readmitted into the United States if you leave voluntarily, or it may prevent you from ever becoming a naturalized citizen. You also have the right to seek advice from an attorney about the effect a guilty plea will have on your immigration status. You also have the right to pretrial release. You may be released today with conditions unless the prosecutor has filed a pretrial detention motion or if you have outstanding detainers that cannot be resolved today. If the state has filed a motion for pretrial detention, then and they have, and your case will be heard. It's going to be consolidated and heard today to determine whether you are you may be safely released or must be detained pending trial. At that hearing, the state must establish probable cause that you committed the alleged offense. You will have the right to an attorney, and you do have an attorney representing you here today. You will have the right to testify, to present witnesses, to cross-examine witnesses who may appear at the hearing, and to present information by proffer or otherwise. Testimony given during the hearing shall not be admissible against you on the issue of whether you are guilty, but your testimony may be admissible in proceedings related to pretrial release, violations of the conditions of release, perjury, or for purposes of impeachment. Under the court rules, the state can request a 3-day postponement of the detention hearing. You may request a 5-day postponement of the detention hearing. While awaiting the hearing, your commitment to the county jail will be continued. If the state withdraws its motion before the hearing, you'll be brought back to court and released on your own recognizance or with conditions of release. However, if the prosecutor has not filed a motion for pretrial detention and you do not have any outstanding detainers, you will be released on your own recognizance or with conditions of release. As a condition of release, you must provide a valid mailing address at which you receive and regularly check mail. You must notify the court handling your case of any change of address. If you fail to notify the court of any change of address and miss a court appearance as a result, a bench warrant may issue for your arrest. Please provide court staff with your mailing address, cell phone number, home phone number, email address, and the best way to reach you in the event that the court staff must notify you of a change to your scheduled event. In addition, the court may assign other conditions of release. You must strictly adhere to these conditions. Failure to do so may result in a bench warrant being issued for your arrest or the revocation of your release. If you are charged with an indictable offense, you have the right to have a hearing as to probable cause and the right to indictment by the grand jury and trial by jury. You may also choose to waive an indictment or a trial by jury. If you choose to waive a trial by jury, you will be tried by the court. In that instance, a judge will determine whether you are guilty or not guilty. You may be eligible for the pretrial intervention program. You may also be eligible for the drug court program. In order to be considered by these programs, you must submit an application. Staff in the courtroom will direct you to relevant materials for making these applications. A special note for military veterans, a program called the Veterans Assistance Project exists to provide veterans with referrals to community-based resources for services related to housing, mental health counseling, substance abuse treatment, financial aid, legal services, education, and veterans benefits, including possible monitoring by another veteran. Our court staff can provide you with a brochure describing the program and an application. Staff can also help you with completing the application. All right. That concludes the statement. I would ask that the prosecutor read the charges.
Thank you, Your Honor. Mr. Caneiro, first and foremost, warrant 2018-00079013-7 alleges that on or about November 20th, 2018, you did commit the crime of aggravated arson, specifically by purposely or knowingly placing another person in danger of death or bodily injury, and or with the purpose of destroying the building or structure of another. To wit, you did set fire to your residence by using gasoline, igniting the gasoline, causing the residence to catch fire while your wife and 2 daughters were inside. That is in violation of NJSA 2C 17-1A1 and or A2. Here is a copy of your complaint.
Record will reflect the defendant's concern with the copy of the complaint.
Thank you, Judge. And Mr. Caneiro, W 2018-000005 58-1304 alleges that also on or about November 20th, 2008, within the jurisdiction of this court, you did purposely or knowingly cause the death of Keith Caneiro or serious bodily injury resulting in the death of Keith Caneiro. That's a first-degree crime, contrary to NJSA 2C 11-3, A1 or 2. It also alleges that within the jurisdiction of this court, you did purposely or knowingly cause the death of Jennifer Caneiro or serious bodily injury resulting in the death of Ms. Caneiro, a first-degree crime contrary to the same statute. The third charge is that you did purposely or knowingly cause the death of J.C., a juvenile, or serious bodily injury resulting in the death of J.C., also a first-degree crime. The final murder charge alleges that you did purposely or knowingly cause the death of S.C., a juvenile, or serious bodily injury resulting in the death of S.C., crime of the first degree. You also are charged with purposely starting a fire on the property of another, to wit, 15 Willowbrook Road in Colts Neck, New Jersey, owned by Keith Caneiro and or Jennifer Caneiro.
Trying to see if there's any other
Purposely or knowingly
hearings.
placing another person in danger of death or serious bodily injury, or with the purpose of destroying the structure of another. This is a second-degree crime contrary to NJSA 2C 17-1A1 and or 2. You also are charged with a second-degree crime of possession of a firearm for an unlawful purpose. By purposely or knowingly possessing a firearm with the purpose to use it unlawfully
found
against
one.
the persons of Keith Caneiro, Jennifer Caneiro, Sophia Caneiro, or Jesse Caneiro. Finally, you are charged with unlawful possession of a knife for unlawful purpose, a third-degree crime for using it unlawfully against the person of the
I think Devyn's back. Maybe not.
Judge, that culminates the reading of the complaints. I will provide this last warrant to Mr. Caneiro.
All right, record will reflect that the defendant has been served with a copy of that complaint as well.
No.
Just want to add anything at this point?
Judge, at this point, we acknowledge that my client has been served in regards to these particular complaints and ask that a not guilty plea be entered in regards to all of these complaints.
All right, so noted. All right, we are joining today the first appearance along with the probable cause and the detention. How will the state be proceeding as the probable cause?
Judge, our intention was to proceed by way of proffer with respect to both.
Court is back, but they're not on her.
Mr. Ansel and Mr. Honaker with respect to this. And it's my understanding that based upon the discovery they've received and the knowledge they have of the case, they are going to be stipulating that probable cause does exist based upon the discovery as of now, and it's for purposes of this motion or this detention motion, or both detention motions at this time. That being said, it's also my understanding that once that probable cause determination is stipulated there too, they will be consenting to Mr. Caneiro's detention, continued detention through the culmination of these matters. That is my understanding, Mr. Ansel and Mr. Honaker, I believe.
Yeah, I don't think they ever got out of jail.
All right, Mr. Honaker, Mr. Ansel, is that your understanding?
That's correct, Your Honor.
It is, Your Honor.
In regards to this particular matter, we will not contest probable cause at this juncture. We stipulate the probable cause at this juncture, but reserve the right to challenge probable cause should there be any additional motions, such as motions to suppress evidence or motions to dismiss the indictment.
All right, very good. Probable cause, as we know, is a well-grounded suspicion that an offense has been committed, that the defendant committed it. That's State versus Sullivan, 169, New Jersey 204. I will accept the stipulation of probable cause, and we will move on to the detention phase of the proceedings. It is my understanding that detention is being consented to. That is correct?
That's correct, Your Honor. We had an opportunity to fully advise our client as to the nature of the detention hearing. Our client has indicated that he wishes to consent and waive his opportunity to have a detention hearing, and we've advised the prosecutor's office of our decision in that matter.
All right. Well, at this point, I'm going to place him on the record and read to him his rights that he would have had the detention hearing proceeded, so that the record will reflect that there is a knowing involuntary waiver of the rights. Please stand, sir.
Place your left hand on the Bible.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record and spell your last name.
Paul Caneiro, Caneiro.
All right. Mr. Caneiro, you have the right to be present at this hearing, which you obviously are. You have the right to have counsel, which you do. And at a detention hearing, you also have the right to be provided with all statements or reports in the prosecutor's possession relating to the facts on which the state bases its pretrial detention application. Mr. Decker, have you provided all this information to the defense?
Judge, I have. We've provided on several occasions over the course of the last, I think, 10 days. And it's my understanding that anything that's been potentially exculpatory would have been turned over, but I don't believe that there is any at this point.
All right. You also, sir, have, Mr. Caneiro, have the right to be furnished with all exculpatory evidence. That's evidence that would tend to exonerate you, known to or in the possession of the prosecutor. Mr. Decker, you have provided that as well, all exculpatory evidence known to you in your possession?
Yes, Judge, I have.
All right. You also have the following rights at this hearing, sir. You have the right to present witnesses, you have the right to cross-examine any witnesses who may appear at this hearing, and you have the right to present information by proffer or otherwise. You understand each of these rights, sir?
I do.
All right. You also have the right to testify at this hearing. You do not have to testify if you choose not to do so. If you do elect to testify, your testimony shall not be admissible on the issue of guilt in any other judicial proceedings. You understand that, sir?
I do.
I should advise you, however, that if you do elect to testify at this pretrial detention hearing, your testimony shall be admissible in any or all the following proceedings. Any proceedings related to your subsequent failure to appear when required, if applicable. Any proceedings related to any subsequent offenses committed during the release, if applicable. Any proceedings related to your subsequent violation of any conditions of release, if applicable. Any subsequent perjury proceedings, if applicable. And for the purpose of impeachment in any subsequent proceedings, if applicable. You understand your right to testify or not to testify, as the case may be?
I do.
Has your attorney explained each of these rights to you?
Yes.
Has your attorney answered all of your questions regarding your rights at the detention hearing?
Yes.
You need any more time to speak with your attorney about the detention hearing and your rights at the hearing?
No.
All right. Counsel for the
And I
defense,
was
have you
muted.
explained each of these rights to your client?
We have, Your Honor.
All right. Are you satisfied that he understands these rights?
Yes.
Have you reviewed with your client the information?
I apologize. I just turned them on.
Have you had enough time to discuss this matter with your client?
We have.
All right. Now, one more thing, Mr. Caneiro, is anyone forcing you to waive this pretrial detention hearing?
No.
Are you under the influence of any drugs or alcohol today?
No, I'm not.
Do counsel have any additional questions relative to this waiver of the detention hearing?
No, Your Honor.
Does they have any further questions?
I do not. I'm satisfied.
All right. I'm satisfied that having read defendant his rights that he would have had at the pretrial detention hearing, that he's knowing and voluntarily waiving his rights, and I will direct that he be detained. Anything else from counsel? No?
No, Your Honor.
No, Your Honor. That concludes the matter. Thank you.
All right, so that's all for his arraignment video. I have switched over to law and crime instead of court plea. And according to Kathy Rustin, who is very reliable and part of law and crime, she says that they are doing a different sentencing right now. And the sound will come back on when in Devyn's turn. They're still waiting for her sentencing. I don't know why they're not just playing all of them right now. A bunch of people are like, this is the weirdest sentencing we've ever seen, to which I agree. Kathy just posted, this is how things work in that Vegas courtroom. The judge runs her normal docket. We are only told to be there at 9 a.m. and then we wait. Love that for us. Love that for us. So, who knows? Who knows when that's going to happen? Love that. Love that. So I do have let's see, I think this would be his last hearing. This is what, 4 months ago? It's for Paul Caneiro. It's a pretrial hearing. Doesn't really say what they're covering. Oh, they're reviewing the final details of the trial, including the jury evidence and media coverage. So we could watch that too if you guys want. But it is like an hour and 47 minutes. So I don't know how much you guys want to hang out today. And then we can switch back and forth when her sentencing comes up. We should probably change the title to this stream, by the way. Let's do that. Okay, so let's do this tab instead. And I have Devyn in my ear too. So as soon as I hear it come on, and that it is her, because they've done it a few times where they brought the audio back on and they're not talking about her case at all. And then they turn the audio off. So I will switch us back and forth then. And do that. Oh, wait, no, I saw that in the long crime chats, not on X, on their YouTube chat. So you have time to hang out, Tracy? Good. Let's hang out then. All right, so this is, I can get rid of this one so it doesn't like bog my stuff down. Oh, chat is saying that the sound is controlled by the judge for the stream. That's interesting. Anyhow, all right. So this is from just a few months ago. I'm excited to learn how to pronounce the judge's last name. I think it's Lemieux, but I don't know. I only took 2 years of French and I'm not great at it. Oh, she said the same thing on X. Oh, okay. All right. Good afternoon, Mama. Did I miss anything? No, because their sentencing hasn't actually happened yet. We're waiting. They did a bunch of arraignments in the same courtroom, and we're just waiting for them to get to her sentencing. So once it does, we'll pop over there and watch that. But now we're going to watch the pretrial motion hearing, for our next trial that will start next week, New Jersey versus Paul Caneiro. So we're going to watch this while we wait for Devyn's sentencing. But I have it in my ear, guys, so don't worry. We'll know exactly when it happens. I'm sure I'll get the lovely noise. Ugh, I hate it. All right, let's see what this is about. Let me turn on those closed captions so I don't forget like last time. And let's see what we're going for. This is the courtroom that I know the trial is going to be in. I'm pretty sure. It's very interesting looking. Turn that up. Hopefully they say words. That would be great. Let's zoom here.
Judge Chris Decker, Assistant Llama County Prosecutor.
Good morning, Your Honor. Monica Mastelon on behalf of Mr. Paul Caneiro, who's present in court.
Good morning, Judge Andy Murray for Mr. Caneiro. All right. Good morning, everyone. Good morning, Mr. Caneiro. All right. So we're here this morning for several reasons. We've already had the pretrial conference.
You guys hear that good?
Back about a week or so ago. But we're back here today because since the last time it's actually a couple weeks ago, but since that last time, the court has rendered the last two decisions that were outstanding, dealing with the state's motion for certain intrinsic evidence to be admitted into court. The court's made that determination. The court has also ruled on the ballistics testimony in this case, indicating that it would allow that testimony at the time of trial. In saying that, the court at the last date also gave both sides the opportunity to file any in limine or evidentiary hearing motions that were due by last Friday, August the 8th by noon. I did receive several in limine motions by the defense, so those will be discussed today as a part of the overall conference that we're going to have this morning. We're also going to discuss some of the other outstanding issues that we still needed to discuss from the pretrial conference. So let me start with this. We have gone back and forth with the verdict sheet. It was supplied to me by both counsel I had an opportunity to review it.
Oh, good. They're getting
I
this stuff
made
out of the
some
way.
corrections and or some stylistic changes and one correction to it and sent it back to the parties. At this point in time, are we all in agreement as to the verdict sheet as it's been presented and we've all reviewed?
The state is okay with the judge based upon the revisions that the court made.
Okay.
The defense agrees, Judge.
Okay, great. All right, so that one is taken care of. The second issue that we discussed at the last conference that I want to bring up again here today is the issue of note-taking. This trial, as it's presently scheduled for, is scheduled for September the 8th, and we're going to tell the jurors that the trial could potentially go to the third week in November. Because of that extended period of time, the court requested the positions of both counsel as it relates to note-taking in this case. On a normal case, you don't really need to have note-taking because the jurors could watch, they can remember. But because this trial is going to be so prolonged, I had brought up the issue for the both counsel to consider. While I have received some preliminary thoughts from both counsel as it relates to note-taking, I wanted to put it on the record here today because I do have some concerns that if we don't allow for some form of note-taking, that it would potentially create a significant number of readbacks later on when the jurors are deliberating. I should give you so that you have some understanding about what I mean by note-taking. So the way it would be set up is that each juror for each one of their chairs would have an assigned notepad. It would have the number on the back of the actual cardboard that would say juror number 1, juror number 2, all the way down to juror number 16. Those pads will be placed on their chair each and every morning by my court staff. The jurors would be able to write on them throughout the course of the day. On breaks, they would leave them actually physically on their chair. They wouldn't be able to take them with them. They would have to leave them right here. At the end of each day and at lunchtime,
so they usually don't
my staff would actually take those notepads, keep them. They would be kept in my chambers during the course of overnights and for during the lunch hours so that no one would be able to have access to them and or be able to read them for any notes that they may have. And then they would be put back on their chair for the next day. As the trial goes on, if they have more than one notebook, we would give them additional notebooks as they requested it. And then they would be given the opportunity to use as many as they need. I would suggest that what we would do is, because they don't need to go back and refer to their notes during the course of the trial, once they were done with notepad number 1, they wouldn't see that notepad again until they were done, and they can have that in the jury room as part of their deliberations. So that's kind of what the way that I envision it. However, I'm open to suggestions from both sides, and or if your position is that you don't think note-taking is necessary for this case. With that being said, I'll start with the state and your position as it relates to note-taking.
Yeah, Judge, obviously I understand the court's concern, and the last thing that anybody wants is a situation which seems to be far too common about readbacks and more readbacks and things like that. I'm just not so sure that the goal that we're trying to achieve is necessarily going to be assisted by the note-taking, especially when the court's talking about how, if they finish one notebook, then they get another notebook. I'm concerned that it's going to become a situation, which is, I think, why jurors don't generally take notes, at least in this county, for the last several years. It's because it does breed somewhat of a less paying attention as opposed to, hearing and writing. I think just jurors paying attention is the best thing for everyone, in my humble opinion. That being said, I think if the court was going to kind of decide on its own that note-taking is the best scenario, which the court can do, and it's not an issue that is going to leave me, crying at home tonight if the court went the other way. I do think, though, that the court should give that logical instruction that hey, you don't have to write down every single thing. Like, this is just, the only reason we're giving you the notepad is because it's going to be somewhat of a long trial. And we want to ensure that, you know, your recollection is recorded in some way at the times when it needs to be. You know, I don't know, I just don't know. And I know that I Googled it very quickly after we spoke yesterday, and I forgot to go back and do it. I know there's a civil note-taking jury charge. I believe there's a criminal note-taking jury charge, or it's based upon my recollection. And I know it's by like a 2-page thing, and it may include some of that stuff. I will take a look at it. But I do think I worry that by trying to alleviate readbacks, we're now having a bunch of jurors that are going to be in a room for 3 weeks comparing notes during deliberations. And that's really what I worry about. I just think paying attention is the best way.
I missed it. Is he the
despite
defense
having never been
attorney
a
or
juror to be a juror.
All right. From the defense?
Judge,
oh, that was the state argument.
so
Okay.
with the understanding that the court does, this is an issue that's within the court's discretion. I recognize that. And I know it's guided by Rule 1:8-8B. With that said, though, the defense would object to note-taking in this particular case. And here's why. So I learned this fun fact about multitasking a long time ago, that we think that we can multitask. We can do multiple things at once, such as listening and taking notes. But actually what our brains are doing is just very quickly going back and forth from one task to another task. So we perceive it as multitasking, but our brains are actually just very quick at changing function, and we're not actually doing two things simultaneously. So with that said, Judge, I think our justice system and our New Jersey case law has recognized the concerns. In State versus Jump 261 NJ Super 514 at 525, quoting another New Jersey case, Wigler versus Newark 125 NJ Super 179 at 182 to 183, they just expressed that the appellate division expresses some of the general concerns. And they state the reasons advanced against this practice, meaning note-taking by jurors, include the contention that the taking of notes by a juror may tend to distract his mind from the evidence which is being presented while he is taking notes, may distract the attention of other jurors from consideration of the evidence being presented, may tend to overemphasize either to himself or to other jurors the evidence on which he is taking notes. Further, that the taking of notes might tend to be a confusing element for those jurors not trained or skilled in the note-taking process. And I think we have to keep that in mind, Judge, that these jurors are normal people like us. They're not trained stenographers. And so I do think that the process of taking notes will distract from their ability to pay attention to the evidence. And more specifically, Judge, my concern is that, you know, we all know the case, right? Because we're the lawyers and Your Honor has presided over the matter. So if a witness is on the stand, we generally know what to take down, right? Because we know like what points we want to make sure to get to the jury. We want to make sure we
Lots of
know
states do
certain
this,
things that the
so
witness is saying that we want to
interesting to
address
hear the
perhaps.
argument,
But
though.
the jurors are coming into this as they're supposed to be blank slates for the most part. So my concern is that they will not know what is important. We're just throwing a massive information at them. And I think unless and until you take a step back after hearing all the testimony, that's when you can start to kind of piece it all together and say, well, I think this is important. I think this is important, especially when you have it presented to them the way it is, which is by witness. So it is kind of piecemeal. So my concern is that you have a witness on the stand and they're talking about, you know, like maybe just describing generalities of the crime scene. And they're noting down all of these things that maybe aren't actually relevant, maybe not something in dispute by the parties.
You don't get to decide
and then the
what's
witness
relevant.
says something important and they miss it because they're too busy taking notes about things that really they probably didn't need to take notes about. So I think my concern is that if we allow them to take notes, it's going to distract from their ability to actually to ensure that they are paying attention to what is important, to everything that's being said on the witness stand. And Judge, also, you know, I think that it would be an easy mistake to make given the complexity of the case. and the multiple moving parts. So if we have a DNA analyst on the stand and they're talking about probabilistic genotyping, again, my concern is like
I
they're
can't
going to be
remember
writing
even
down
anything I talked
maybe
about
the
yesterday
basics
or
of
the day
DNA
before.
and miss an important point about a more complex issue. I think also, Judge, the problem with note taking is that you're looking down a lot, right? I mean, we can type without looking down, but we typically can't write without looking down. So I think it's really important for each and every question that is asked of this witness and each and every answer that the witness is giving, whether on direct or on cross, that the witnesses have the opportunity to have their undivided attention on that witness so that they can observe body language and they can observe eye contact and they can observe the characteristics that Your Honor instructs them on in the beginning or at the end and says, when we talk about credibility of a witness, you can take into consideration all of your observations about that witness. And that could be missed if they're looking down while they're writing. In addition, Judge, the jurors should be looking at the actual evidence that's displayed to them. So they might miss, like, if the state has a detective on the stand, the detective is showing crime scene evidence. They might miss a detail if they're looking down. I also agree with the state that it will cause the jurors to rely on those notes rather than their own memories. And because they're not trained stenographers and they can't shorthand every single thing that's being said, they could make mistakes in their notes. They could mishear something and now it's memorialized. And now the jurors are inclined to rely on that as opposed to what their independent recollection is. It's easy to mishear testimony or mistake it and write it down and then later inappropriately rely on that. And again, when we're dealing with more complex forensic sciences, that is I think a higher risk that could occur here. The notes could be partial or incomplete and later misinterpreted by the jurors. It also lends to a possibility where jurors are, certain jurors who have better notes, so to speak, or more thorough notes, so to speak, might kind of take on a more leadership role in the deliberations as opposed to, I think, the ideal dynamic, which is that each individual plays an equal part in the discussions. Even just—
You don't have to keep going. I'm going to agree with you. If you want to keep going, though, you can.
Meaning Your Honor is not going to order note taking? Okay. Thank you, Judge.
He's not ordering notes. So no.
The thought behind it was exactly what I said. Based upon the positions of both parties, I will not order note taking under the circumstances of this case, and we'll go forward and see how it goes. All right. Next is the issue of we have discussed the statement of the case. Obviously, the statement of case will be provided to our prospective jurors to make sure, just based upon the limited information that we give them, whether they're going to be able to be fair and impartial or not. Both sides have had an opportunity to look at that. I'm just confirming that we are good on the statement of the case, correct?
That's correct.
That's right, Judge.
All right. Next is the preliminary charge preliminary model charge that I gave to the jurors, or excuse me, that I gave to the counsel, that I would read to the jurors after we go through the initial screening process to get jurors that would be able to sit for the period of time for this trial. Did everybody have an opportunity to look at that preliminary model charge, and is everybody okay with that?
We are, yeah.
Judge, I did have an opportunity to look at it, and I appreciate that the court incorporated many of those questions for the searching voir dire. If that's what Your Honor—
Not there yet. I'm only on the preliminary model charge.
Oh, yes, Judge, that's fine. Thank you.
Okay, all right. But I'm going to get to that, I promise. All right, so let's talk about now the voir dire question. So for the record, the court put together a list of voir dire questions, which includes a lot of the searching voir dire questions that the defense was concerned about. Normally there's 28 or 29 questions. We now have 39 questions to make sure that we address these issues. And I want to be abundantly clear, if there are any questions that I find that a prospective juror is waffling on, I will dive in and make sure that I ask a significant number of questions to make sure that we get a fair and impartial jury in this case. But I did try to address all questions that the defense were looking for as it relates just to the yes and no questions. We'll get to the open-ended in a second. But in saying that, does anybody have any issues now with those questions, the 39 questions that we have?
The state does not, Judge.
Okay.
I think it's 38, Judge, because we took out that 33 and replaced it.
Oh, that's not a very long.
You're correct.
year.
We did. We moved that. We were going to make that in the open-ended question. So there's 38 now, but you're correct. So from the 38, any issues with that?
I don't have any issues, Judge. I just wanted to ask for a quick clarification.
Of course, go ahead.
Which is simply that when I originally submitted my proposed change of venue related searching voir dire questions to the court, they were obviously open-ended, and the court converted them to yes or no's.
Right.
So I just want to confirm we're doing this in the traditional sense that when the jurors have yes answers, we'll call them to sidebar and discuss them. So there may be some follow-up at sidebar.
Yes, 100%. So what will happen is that after we have a large group of qualifying jurors, we will then bring up somewhere between 50 to 100 in this courtroom. We'll put our first 16 in the box, but I'll ask the entire group all of these questions. They'll have a check off sheet that will have just each number where they can check off all their yes answers. I will then start with juror number 1 and ask them, do you have any yes answers? If they do, I will go through each one of them with them. I will probably do that, a majority of that, at sidebar. To be clear, we're going to do sidebar right in front of here. We're not going to do it on the side. So you'll come up with your notepad. We'll make sure that if you want, for Mr. Caneiro's purposes, that if he wants to have headphones so that he can hear what's going on up here, he'd have the opportunity to do that. Unless you want to do the shuffle method, that's up to you. And then I'll question that individual juror. Once I know that they're qualified or not, and with those answers, I would put them back. Once I get through the 16, then I'll come back. We'll do the open-ended questions together with everybody, and the biographical questions with everybody. If that answers you.
It does. Can I make a suggestion, Judge?
Sure.
/ maybe an objection. I would just ask that the open-ended be asked at sidebar as well. I think particularly in a case like this where we're talking about people's opinions about, firearms and things of that nature, I would prefer to have people feel like it's more of a confidential conversation than have other jurors hear their responses and perhaps tailor their responses or be
this is supposed to run through March
right with their
20th,
answers if they're strongly opinionated people. So I would just, I have had judges suggest doing open-ended questions out in the open, but I've always successfully convinced them. So I'm hoping I can successfully convince Your Honor that we do it at sidebar. That's how I've always ended up doing it. And I think it just, it preserves the integrity of the open-ended question process.
Mr. Decker.
I essentially defer to the court. The court obviously has conducted substantial numbers of voir dires in the past.
Her name, defense attorney
thing
lady,
we have to be concerned
is
about is
Monica
this not taking
Mastialone,
forever.
by the way.
And that I think is a primary concern. We want to have a fair and impartial jury, but we don't want it to take forever. And I don't personally think it really should take forever.
And look, we're in a situation now where New Jersey, we are also looking at, in certain cases, not in this case, but in certain cases, doing attorney conducted voir dire where we have people's opinions are being addressed by everyone. And to the extent that a sentence that may be said by juror number 1 has an impact on juror number 6, that they feel differently or triggers them to remember something that they want to say. I don't see the need to do open-ended questions here at sidebar. I like the idea of having communication with them so that they feel a little bit more comfortable in here. So your objection is noted for the record, but I'm going to do the open-ended questions from the from the jury box. I know you wanted to say something, so go ahead, feel free.
I was just gonna say, Judge, I think it actually tends to be more efficient if we do it after the way that I've always done it is they finish all the yes and the no's, and then if we make it through that without them being excused, then we just say, okay, and we just have 3 more questions, and then you ask the open-ended, and again, it's more of a private situation. I agree with Your Honor. Obviously, New Jersey's transitioning to ACBD, but that's not this case. And unfortunately, what we're unable to do here is ask the jurors, like, well, so how do you feel about the answer of juror number 2, juror number 14? We can't do that. So that's my concern is like, we're asking jurors to express intimate opinions that maybe they don't feel comfortable expressing in front of others, and we may be deprived of knowing their true feelings. So if juror number 2 says, I hate guns, I hate everyone that owns guns, and I think that they're all bad people, then juror number 3 might not disclose, well, I think guns are great and I own 6 of them. Like that's my concern, because it's easy to avoid.
They may do that anyway. I mean, you're assuming that certain answers will be curtailed just by that. People curtail their answers just because they're sitting in the courtroom. Look, I hear what you're saying. The reality is this: you have one experience. This court has an experience that I feel extremely comfortable with the fact that we're going to do open-ended questions in an open forum. So I appreciate it. Your objection, though, is noted for the record. As it relates to the open-ended questions, now that one of the eliminate motions here today was to include a 4th open-ended question. The court, after receiving that eliminate motion from the defense for that open-ended question, as a result of the court's opinion as it relates to certain items of evidence that the state was going to produce, where the defense has objected to it, the court has made a ruling that it would allow that evidence in. That the defense had requested a specific question as it relates to gun possession. I had indicated that I would do that as a supplement, as a question, part of the yes or no questions. It was going to be number 33. However, after a conference yesterday, I believe it was agreed to that we would take out the proposed question number 2, open-ended question number 2, that everyone had agreed to, and now we're actually just going to take that question that dealing with guns. We're going to keep that as an open-ended question. We're going to make that question number 2. So we have 3 open-ended questions, and we have the 38 voir dire questions. Does anyone disagree that I say anything that was incorrect?
We got it. Or wait, they're pointing her. Oh, no, I paused the other one. Don't worry. We're having her sit in the box. Let's switch over here. Don't need that. Don't worry, I paused the other one. We'll get back to that as soon as we're done. Look at that. Raindrops and Feathers summoned her, and here she is. I wish you were here a few hours ago when we started this stream. You have magical powers, Raindrops. Magical powers. See? Less crazy looking hair than you had at trial. Babs. It was rough. It was bad. Let me turn on the closed caption. Oh, there are no closed captions. Sorry. Hey, now we get to see those juror chairs. Those are comfy looking juror chairs compared to the ones we've seen. Remember the Massachusetts one? Guys have just been sitting on a plank of wood. Basically, look how comfy those look. In the leg room? You are magic. What trial was this again? This is the beheading one. Remember where she was like married to the son, but the dad was like the father of her 2 children, and she was a adult film star. That crazy one. It's her sentencing today, so you may not recognize her because she doesn't have on the horrible wig that they asked the judge if she could be allowed to wear, which was a very bad choice. Yes, that one. Yes, that one. Oh, it was so bad. Remember, we got eggplant pictures. His weird testimony that did him no favors. You guys think she's going to make a statement before she's sentenced? Because I hope she does. Because that's what she did at her first sentencing hearing. And then they're like, oh, I guess we're going to trial. So is she going to have an outburst today? I only say that because we've been waiting for a long time for this to happen. So. Look at you guys over on Twitch playing with all the emojis. Told you it's a fun time. You can follow us on Twitch, Couch Court with Llama, as well on YouTube at the same time. Sorry, I didn't realize there was going to be this big of a delay. Actually, I'm going to go use the bathroom real quick while we're waiting. So carry on. Be kind to one another. Don't burn the place down, okay? Okay, I'm back. Okay, good. I didn't miss the whole thing because I felt like that's probably what was going to happen. Oh, hello, Kelly P. over there on the Twitch. Love that. Kind of reads like Calliope. Calliope. That's cute. I was just thinking about that Paul Caneiro case. I wonder why the other victims were stabbed a bunch of times and then shot with a gun. It's interesting. Because it seems like, only what we know, we won't know until trial starts, but it seems like there was a lot of brutality with the mom and the two kids. It's interesting. And I mean with the dad too. He was shot 4 times in the head. But stabbing children? Interesting. My brain's all sorts of in Paul Caneiro mode of questions. Like, that's just unnecessary. You could just... Well, the judge isn't even in there. Okay. We're going to go back watching the Paul hearing, and I'll keep an eye on this. She could be sitting there forever, for all we know. So I will switch back over to this, and we'll watch that while we wait. Okay, friends?
That we've all discussed.
Judge, we completely agree.
Okay.
Agree, Judge.
Okay. So that takes care of that for now. For my own edification, it applies to both sides. I don't know if the defense, this is even something that you would have to consider. Are there any witnesses in this case that are under the age of 18?
Judge, no, I do not believe there are any witnesses under the age of 18.
No minors.
Okay.
Unless I'm forgetting something, but I don't believe so.
Okay. If there is, for some reason, I need to be notified sooner rather than later. And don't call anybody in here without.
I'm largely confident that there's not.
Okay.
None from the defense.
Okay, great.
So no, there won't be any minor testimony.
So as a reminder, the trial, as I said, will be from September 8th. We're planning until November 26th, which is the day before Thanksgiving. We're going to hope to get that done prior to that day. But we'll see how it goes and how each and every day goes. But I want to tell you the schedule so that we have it for the record one more time. The courtroom will be open at 8 a.m. Every morning so that the attorneys can get in, they can get set up, whatever that they need to do. The defendant will be seated and ready to go by 8:20 in the morning. And assuming that as soon as he's seated, the courtroom then will be open to the public as soon thereafter. So by 8:22, 8:23, so that anybody that wants to come to watch the actual trial, they'll be able to get in around that time. The way that the seating will be set up is there will be 2 rows that will be set up in the back for the media, for any media that wants to attend. There are also this first row here right next to the jurors. That row will be only for people from the courthouse. We won't allow anyone that has an emotional attachment to the case to be seated right by the jurors, so that there will be no issue with that. We will inform that any staff member that's seated there in that first row that they're not allowed to have any communications talking about the case or anything else. If they want to come and watch the case, they can. However, that they're not allowed to have any interactions at all with the jurors during the course of the testimony. We will have, for purposes of family members, we will have a court staff, someone from our court staff here to help escort them in so they have a place to sit, both for the defense side of the case and for the state side. So you can inform the people that are coming to just let the person know at the door, I'm here on behalf of Mr. Caneiro, I'm out here on behalf of the victims in the case, and we'll have them a row set up for that. Otherwise, it's first come, first serve, whoever's here, they get a seat. So that everyone is aware, there's a conference room right outside the courtroom door. that will be set up with media in there. So that conference room will not be available for the attorneys, just in case you need a conference room for some reason. And then the courtroom right next to mine, that courtroom's going to remain open for overflow for people that want to come to the case and they'll be able to sit in there. They'll be able to watch it on a TV.
Oh, wow.
Or if media wants to be in there, they'll also be able to be in there also. So just to give you an idea, we will have this courtroom. We will have the one next door. There will be a conference room. The attorneys should be cognizant of the fact that there is media that's going to be a part of this case, that you should be careful at both counsel table and outside of whomever that you may be talking to, or that things that could be overheard. So you just want to be smart in those conversations. You all experienced lawyers here. I don't need to tell you. I just want to make sure that you're at least informed of what's going on. As I indicated, the testimony will start at 8:45 every day. I do not want people to be late. Everybody in here knows me now. They've watched me through many testimonial hearings. I will be sitting on this bench at 8:44 and 59 seconds. So we should be all ready to go. Don't show up late, because then that will be something the court will address.
Well, y'all are going to get a grumpy llama next
week. End at 5 o'clock each day. However, if there's a reason why that we're very close to finishing a witness and either side says to me, can we just hold on and keep going? I will. All you have to do is tell me. If you don't tell me, I'm going to assume that we're not close and we're going to keep going at 5 o'clock. Or excuse me, we're going to stop right at 5 o'clock and no later. As of right now, we will be going 5 days a week unless noted by the court. We've had some preliminary discussions behind the scenes as to maybe some potential days off. We'll discuss those more once we have a jury and we know exactly what we're doing. But you should be prepared right now that you're here with any of your cases or anything that you have else. You may have other responsibilities going on. You'll be here every day. Like I said, this case will be live streamed. Be careful with the mics, counsel table, and sidebar, things that you may or may not say.
You guys better get all your coffee
We
ready.
discussed this in conference before we started here this morning, any potential stipulations or consent orders. I'm not going to get into specifics of that, but if there are some that are, there is going to be certain stipulations. Here's the court's order as it relates to them. If there's an agreement, the two sides will actually write it up as to what the stipulation is or a consent order that you've agreed upon. That stipulation, you're going to tell me if it's the, you want me to read it, if it's a witness, if it's the prosecutor's just going to read it, or if it's a defense witness and you're going to read it. I don't care who reads it. That's up to you all. But just know that I need to see it beforehand. The stipulations will be signed by the attorneys. It'll be signed by the prosecutor's office, by the defense, and by Mr. Caneiro. You need to understand any stipulations. I will question Mr. Caneiro outside the presence of the jury with the stipulation to make sure that he has seen it, he agrees with it, he has signed off on it, and that we're all ready to go. So just make sure that we've covered that. And then have two copies. We're gonna have one that's signed, which will be for the court, and then one, just remember, a stipulation would go into the jury room for deliberations. So that one will not be signed by everybody. I don't want that to be, that's not necessary for the jurors to see. I'll explain it in a jury charge. So, but the signed one, so we'll have two copies. Sign one for me, one that'll go in for the jury. Any questions on the consent orders or stipulations that we need to discuss?
Hi, Theresia. Hi, babe.
State?
No, Judge.
Okay, defense?
No, Judge. I mean, I understand the court's indicating the court would like the Mr. Caneiro, the defendant, to sign the stipulation, meaning that he has no objection to it.
Yeah, that's all he's saying. He's not agreeing to he's not doing anything other than saying that basically that he's in agreement that we're stipulating to this.
Stipulated at the trial by the parties.
That's it. Okay, we discussed this before, without getting into specifics, transcripts. All transcripts, we ruled on certain transcripts as it relates to coming out of certain facilities And I had indicated if there was something that becomes relevant during the course of the trial that I would not foreclose the
Maybe
state.
bringing
However,
people in
are
for
all other
having-
transcripts, have they been turned over?
Which still isn't there.
Judge, they have, yes.
Okay, and if Ms. Masalone, have you had the opportunity to review them? And are we in agreement as to whatever they say for each one of those particular calls or whatever else that's being transcribed?
We're talking about the transcripts of the body worn camera.
Well, not just the body worn camera, the other transcripts also.
I haven't received yet the transcripts for the jail calls that the state was intending to use, but they were gonna like narrow it down.
Jail calls.
I thought that was done as of July 31st and that
The transcripts have all been turned over.
Right, the, like, of the 200 jail calls, but then we had discussed that the state was gonna narrow down, at least narrow down which calls they were gonna use, so I could supply, my proposed redactions and objections. So I followed up about that, but I don't have that yet.
Mr. Decker, before I respond to this, go ahead.
I don't recall the court imposing an absolute deadline on where, I could be wrong, on which calls we were going to use. We are still working.
Not on the calls. Here's what I said.
This judge is very no nonsense. It's gonna be good. It's gonna be good.
I said that jail calls that will be used must be identified by July 31st. All transcripts for those calls by July 31st. I said any objections to those calls would be by August the 8th by noon. And then I said the state will be allowed to use other potential jail calls if they become relevant based upon testimony during the trial, or if the defendant indicates something that would be inconsistent with a jail call, that would be something that could be considered if he decides to take the stand. That's what I've said at the last time that we were here. So to go back, whatever calls that you're going to use, have you indicated to the defense, these are the ones, and you've provided transcripts?
Can you answer that question again, Judge?
Sure. The jail calls that will be used during the course of the trial, have they been identified and told to the defense?
They have not been identified. The transcripts have been provided, but they have not been specifically identified.
Okay. All right. Because there were so many, what I had indicated is that I would not bar you from using as many as you need if they become relevant later, but out of fairness, if there were certain ones that that you were using, I suggested that you turn those over so that the defense could look at those transcripts so that we're not in the middle of this trial and we're fighting over what a word says in a particular transcript.
I know that we discussed, I recall the specific discussions about taking out the global tel link. This is a call from inmate Paul.
Correct.
Et cetera. I did not recall having to specifically. I'm not saying that I'm right. I'm just saying that's.
Switching to Devyn. Her lawyers are there now.
Said,
Uno momento, friends. They're bringing her in. I just saw her attorneys there. There we are. We'll go back to the other one.
Let's go on the record and see 377-239, State of Nevada versus Devyn Michaels. May the record reflect that Ms. Michaels is present in custody. Mr. Draskovich and Mr. Horvath are here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. This is the date and time set for sentencing. Are both parties prepared to go forward?
We are.
All right, just a couple housekeeping matters. The victim's mother sent a very long, detailed list of money she's out of, but I don't have any documentation.
I did not receive that either.
Okay, so I'm gonna award the $5,000 of restitution to victims of crime, but that'll be the only restitution because there was actually proof of that.
Understood.
Any objection from the defense to that?
No, Your Honor.
Okay, and we did have a discussion about credit, and we have the credit at 780 days. Is that correct?
That is correct.
Okay. State, you also noticed victim speakers. How many speakers do you have?
2.
And pursuant to statute, would you like them to speak last?
Please.
All right. State, since this is the result of a jury trial, you have retained the right to argue.
Yes, Judge, and you've been doing this as long as I have, if not longer. There's a couple of different types of defendants that come before you and that I've dealt with in my career. And there are those that don't function in society. They commit multiple crimes over and over. And then there are those like this defendant who functioned relatively normally for an extended period of time, but committed such an extreme act of evil when she did commit a crime that you have to put her on the far end of the spectrum of evil, Judge. I understand that her lack of criminal history is something that you're going to take into consideration when you determine whether she gets life without her or not. I really just have a question for the court, and I'm not going to try to provide an answer. And the question is this, is a person who is capable of such extreme evil, is that person someone that we want to walk our streets, whether it's 20 years from now, 28 years from now, or not? And you're on the bench, you get to make that decision today. I would just urge you to think about what it must have taken for her to do what she did. Not everyone is capable of that extreme amount of violence. Not everyone, not even some of our worst offenders go that far. There was some statements made at our last sentencing that I would ask you to take it in context with the evidence you heard at the trial. There is absolutely overwhelming evidence of her guilt, and obviously we have a jury verdict at this point. So all that nonsense that was spewed at the last hearing, I think that has been disproven during the course of the trial, and as evidenced by
I don't know if I go with overwhelming.
Delivered. In this case, if you'll recall, it was just a couple of hours on the same day of closing arguments. With that said, Judge, I will submit it to your discretion. Just defer to the victims.
Okay. Ms. Michaels, what, if anything, would you like to say before I put out sentence against you?
At this point, I just feel that
Nothing to say. I just feel bad.
it won't. The family's looking for certain things and I cannot deliver what the family's looking for. And they're here and I just want them to get their, at least part of their anger out. I know no matter what I say, they're still gonna feel the same way. So just let them have their time and that's all I can say.
Thank you.
Your Honor, I like to state I'm going to be somewhat brief. This was the result of a 2-week jury trial. I do appreciate Ms. Michaels' statements and even the lack of her statements. This case has had a bit of a wild ride to get where we are before Your Honor today. You know, the jury, and we all spoke to the jury afterwards, looked at basically one thing, and that was her statement to the police on August 15th. And she has made several statements leading up to this point, and today she's chosen to just basically let the record speak for itself and then the history of this case speak for itself. You know, Your Honor is in a very unique position, being basically a murder trial judge. The thing that I would like the court to take into consideration is the issue of proportionality. You know, you hear on a regular basis cases that involve years, if not decades, of criminal conduct. People that have substantial criminal histories. People that have committed crimes over and over and over again. Ms. Michaels has a gross misdemeanor conviction that was close in time to this case, relatively speaking. She, outside of the events that gave rise to this case, she's lived a very good life. And I think the court should take that into consideration in reference to this issue of proportionality and treating similar defendants similarly and different defendants differently. I mean, when we look at the object or the goals behind sentencing, we have deterrence, we have incapacitation, we have rehabilitation, and then we get to this issue of retribution. And, the flip side of retribution is redemption. You have a woman that stands before you today who's 47 years old. She turns 48 in April. You've got a woman that was a devoted mother. She had a career. Obviously, what occurred is not going to bring Mr. Willette back. Miss Michaels' case, if we take the version of events that the state presented, we have here, you talk about stabbings and crimes of passion and things like that. In this case, we don't have someone that's been charged with lying in wait, planning. We don't have a case where we have a life insurance policy that was viewed. We don't have this, and when we talk about evil, that's kind of a slippery word sometimes. But at worst, what we have here is a conviction based on impulse and then perhaps bad actions that occurred following that. Your Honor spoke with the jury, we heard the testimony. We had this, and she was charged murder with use. And if we take the evidence in the light most favorable to the state, we have something where there have been unwanted sexual advances. There was a candlestick or perhaps a poker that was then used to strike Mr. Willette. And I'm using his name. The decedent, I don't want to minimize, he was a person, obviously, as is Miss Michaels. We have an appeal that's going to follow, but nonetheless, if we take the version of events that the state would have the court take into consideration, we have an act that was based on impulsiveness and then bad impulsive decisions that very well may have followed. Your Honor, and one case comes to mind, I believe it's the Randolph Thomas case. We have a case where there's multiple former spouses, multiple acts. In this case, we have a single act. We don't have this course of conduct that encompassed days, years, or in that case, decades. We have a single act that's now before Your Honor. The very minimum sentence per statute that Ms. Michaels could receive is a 21-year sentence. We're talking 60 years old. And Your Honor knows the studies. Like I said, you're in a very unique position based upon your experience and the depth, not only off the bench prior to your having assumed the bench, but as a murder trial judge. This is a case where the court should look at redemption. She can contribute to the community. She's had no issues whatsoever while incarcerated. In the beginning of this hearing, Your Honor addressed the credit for time served she's been in for some time. I would urge the court to view, to look at the facts and circumstances and the very difficult decision Your Honor has to make with the idea of redemption in mind. I would urge the court to give her, as far as the murder charge, the chance at redemption, the chance to be perhaps one day reincorporated into society. I would urge the court to give her a sentence of 20 with the possibility of parole, and then the minimum sentence for the with use in enhancement. I would submit that this idea of proportionality and true equity and fairness would be served by such a sentence.
Certainly.
On that, I submit it, Your Honor.
Okay, thank you. State your first.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Please state your full name, spelling your first and last name for the record.
Valeria Willette, Valeria Willette.
And ma'am, what would you like to say to me today?
First of all, thank you for giving me the opportunity to speak out. It's been a while, and I'm very thankful. And whatever I'm going to read is what I lived for almost 3 years.
I don't know who she is.
Excuse me. The brutal murder that took place on August 7th, 2023 has forever changed my life, my husband's, and my children's life. I am still in shock and traumatized because of this unbelievable act from someone who is selfish and heartless. About a week after Johnathan's murder, we came across a huge responsibility of taking in 2 young girls who we didn't know, and due to the circumstances, we couldn't say no when all others say they couldn't. My life has changed since the notification of my stepson's death. With us taking in 2 girls with us taking 2 girls in our home and getting to know them and not knowing of all the trauma they previously had, after the murder, even more trauma was added. It has been a tough 2.5 years for all my family. Grieving has been hard at home, since there were times when I needed to break down and cry, but I couldn't because we had 2 girls who depended on our strength. Along came caseworkers, CASA, Boys Towns, and CAP attorneys who visit our homes several times a month. This doesn't include the process of getting fingerprinted, classes to be able to assist the girls while with us, and therapy for them and myself, husband on weekly basis. The girls did not have discipline, boundaries, basic cleanliness, social skills, and proper hygienes. The clothing they brought from Child Haven was unfit for anything except playtime. I contacted their stepfather/brother, Davier, to see if we could pick up more clothing, and those were not much better. We ended up spending a lot so they could look presentable when in school and out in the community with us.
Johnathan,
we also have to deal with Casey, our daughter, who was in senior year and fell into depression, making it hard for her to be in school and caused a lot of absences. It was a huge change in her life, having to deal with 2 young girls with so much trauma. And Casey graduated in June of 2024. It has been very hard on us since no other relative has assisted us in caring for the girls, only my immediate family members, which are my adult children. We have now built a relationship with Aunt Kayla, the killer's sister. She stopped by while she was in Las Vegas on business, and we had a great conversation, and she departed as a supportive aunt. Because of this meeting, the girls have changed their minds of what kind of person she is. We will continue to nurture this relationship with Aunt Kayla and the girls. Through Johnathan, we have gained a true friend who has supported us, especially me. We grieve together, and Bernadette has also lost a best friend. We talk, cry, and express our sorrows about how a person was taken away so brutally. We cannot bring Johnathan back. God has gained an angel in heaven. We believe he is watching over us and the girls. I ask today for justice for our family, especially the girls, because we have been sentenced for life with this tragedy. This will follow them for the rest of their life. We've created a time capsule for them in therapy where they can place notes or items that they can open in the future to remember their journey. We will never again hear his voice, his laughter, or see his expression. Johnathan doesn't have a second chance. His life has been taken, never to return to us. The girls have been left without a dad, stepfather/brother who doesn't make contact with them, and a mother who's in jail. After my marriage of 14 years, I have come to know Johnathan. Although we didn't have a close relationship with him, I miss his jokes, laughter, and him being funny. He would come around on holidays and enjoy our time spent with him. Thank you for allowing me to speak about the situation, and I am seeking the hardest penalty in this case. The killer that ended Johnathan's life needs to be put away forever. Thank you.
Thank you very much.
That would be
and thank you
Johnathan, the
for being here
victim's
today.
stepmother. We'll definitely recap all the things she said. Interesting. Devier hasn't been around at all. He just went and fucked off. To the surprise of none of us.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your full name, spelling your first and last name for the record.
James Willette, JamesWillette.
And sir, what would you like to say to me today?
I have a prepared statement
Okay.
that I would like to have you listen to.
Okay, whenever you're ready.
May I have a seat?
Sure.
Your Honor, I must apologize as I'm uncertain of the appropriate name to use. Tracy Reed, Tracy Tavares, Tracy Baker, Devyn Michaels, Nikki Fairchild. But for clarity in this context, I will refer to her as the killer and murderer of my son, Johnathan.
I forgot about all her names.
This horrendous murder crime has affected her two precious children, myself, my wife and my children in the household, my wife's mother, my wife's brother and sisters and their families, my ex-wife and her boyfriend, my remaining son, my grandson who married her, his mother and family, her parents along with her sister's family, and anyone who knows us or were friends with Johnathan. We have all been given a life sentence by a woman who doesn't respect life. She has removed from our lives my son, her daughter's father, her daughter's stepbrother, and all related individuals that were just mentioned. The enduring loss of opportunities to communicate with Johnathan, witness his achievements, and provide guidance is permanent. This absence is not limited to life without parole. It is not replaceable. Each day serves as a reminder of this lasting impact, which will persist indefinitely. Regardless of the duration of her sentence, we continue to experience an ongoing sense of loss that will endure throughout our lifetimes. Our circumstances remain unchanged, and correspondingly, there should be no alteration to hers. As we grapple with the magnitude of what has been lost, we find ourselves thrust into unfamiliar roles and responsibilities, forced to adapt and preserve in the face of relentless adversity. The routines we once knew have vanished, replaced by an ongoing quest to provide love, safety, and guidance for young lives so suddenly uprooted. Our whole household has become a place of both deep sorrow and determined resilience as we navigate the labyrinth of legal proceedings, therapy appointments, and daily challenges that arise from the tragedy of this scale. The weight of grief is compounded by the necessity to advocate fiercely for our grandchildren, ensuring their emotional and physical needs are met, even as we contend with our own sense of devastation. Despite the overwhelming nature of these circumstances, we are steadfast in our pursuit of healing and justice, propelled by a profound sense of duty to honor Johnathan's memory and to safeguard the well-being of those he cherished most. The tragic passing of my son, Johnathan, has had a profound impact on many individuals, including his two beloved children, his mother, our family, all relatives, the killer's parents and sister, as well as friends and acquaintances of his. We have all received an extreme life sentence, not a 15-year to life term. We have no parole. We just the knowledge and the heartbreak of his loss.
Uh-oh.
Life has taken away my son, her daughter's father, her daughter's stepbrother, who is also her husband, and all others mentioned. The opportunity to communicate with my son, appreciate his life, witness his achievements, and provide support through advice is permanently lost. Every day we are reminded of this irreversible consequence. Nothing will change in 15 years, 20 years, or even our lives. Regardless of any duration served by the killer, Johnathan will not be returned to us. His actions are permanently ceased, and his voice will remain silenced forever. We are enduring a lifelong impact until the end of our days. This situation remains unchanged for us and thus should remain equally unaltered for the killer. We are consistently reminded of the serious impact of the killer's action on her life. Each day, the killer's daughters wake up to the reality that their father is no longer part of their lives, preventing them from sharing any experiences or creating memories with him. They experience significant long-term effects due to growing up without parental support, relying on grandparents, relatives, and others for assistance during a limited period before achieving independence. We are optimistic that they will understand they are not responsible for these circumstances and their future choices will help them avoid entering this system. Despite this, they will carry the burden of their mother's actions, knowing she has effectively removed both parents from their lives. These events have left 2 young lives facing significant challenges in their futures following the loss of their father due to her mother's actions. The recent events have been particularly traumatic for our family, especially for the children. My wife and I have attended classes to assist in raising our granddaughters and addressing their trauma. We are supported by caseworkers, CAP attorney, CASA worker, Boys Town worker, therapists, special school classes, coaches, and the daily challenges resulting from the loss of both parents.
Ew, kissing.
This situation has impacted everyone involved. We have observed changes in attitudes of our relatives and friends due to this event. Both my wife and I have consulted a therapist for support, which has been beneficial, though the issue remains prominent in our lives every day. We have attended numerous court dates related to both the murder trial and the cases involving the child abuse and termination of parental rights. The significant time spent traveling, communicating with district attorneys, and enduring the anticipation of trial outcomes has severely impacted our mental health and well-being. Such experiences are immensely challenging, particularly when one child is tragically taken by murder, as Johnathan has. As a retiree, I anticipated enjoying my golden years, but now my wife and I find ourselves responsible for raising preteens once again. It is essential to emphasize that while we deeply care for the girls and are concerned about their future, proper medical care and dedicated personnel can help ensure they lead normal lives. We are making notable progress with Janaea, who is determined to improve her life and situation. Despite holding 3 licenses, foster kinship, relative foster home advanced foster care, and professional caregiver pre-service training, we continue to enhance our understanding of the trauma experienced by our granddaughters. These children have never experienced loving discipline, nor had real interaction with others, as they were homeschooled rather than attending school. Consequently, there is a significant lack of etiquette, in social environments and personal interactions with peers and friends. This is especially difficult for us in a family setting or gatherings on special occasions. Throughout this difficult and painful experience, our resilience has been tested beyond measure as we navigate the complexities of the judicial system and endeavor to provide a stable environment for our granddaughters amid relentless adversity. The emotional and practical burdens we bear have transformed our daily existence, challenging us to find strength in one another and in support systems available to us.
I know.
Despite the constant reminders of the loss and the enduring pain etched in every aspect of our lives, we strive to foster hope for the future of our grandchildren, advocating for their safety, well-being, and justice in the wake of such irreparable harm. We have faced countless obstacles in our efforts to piece together a sense of normalcy, persistently navigating bureaucratic hurdles and emotional turmoil while every aspect of our daily existence has been altered.
She enrolled them.
Every future plan reshaped by consequences of a single unforgivable act. The weight of responsibility continues to rest heavily upon us as we advocate for justice and stability, not only for our own heart, but for most importantly, for Johnathan's children whose futures have been so deeply scarred. We are requesting per Marcy's law, the Senate Joint Resolution SJR Section 1, letter G, to reasonably notice of all public proceedings, including delinquency proceedings upon request at which the defendant and the prosecutor are entitled to be present, and all parole or other post-conviction release proceedings, and to be present for all of these proceedings. Section N, to be informed of all post-conviction proceedings, to participate and provide information to the parole authority, to be considered before the parole of the offender, and to be notified upon request of the parole or other release of the offender. Section P, to have all monetary payments, money, and property collected from any person who has been ordered to make restitution to be first applied to payment to pay the amounts ordered as a restitution of the victim. As we move forward, it remains imperative that the lifelong consequences endured by our family, and especially our grandchildren, who will endure this crime for many years, are gone, are met with unwavering commitment to accountability and truth. The emotional scars, the logistic obstacles, and the persistent sense of emptiness cannot be erased. But through steadfast support and continued vigilance, we hope to honor Johnathan's memory and instill a sense of security and justice for his daughters. We deeply care for our grandchildren and find it challenging to come to terms with the actions taken by their mother, both regarding our lives and more significantly, those of her children. The impact of this trauma may have lasting life on them. For instance, there is uncertainty who will accompany them during important events such as walking them down the aisle, at their weddings, graduations, birthdays, etc. There are moments in life when one must pause to reflect on one's circumstances. We examine all the known facts and attempt to understand them. The court hearings related to both determination of parental rights and the criminal case. This planned and calculated murder, and remind it was planned and calculated, is not justified in any way or manner, and the killer needs to be incarcerated for the rest of her life. We respectfully request that the maximum penalty behind bars without parole be imposed for this heinous crime. We consider the act of killing and decapitating the father of the killer's children and husband to be egregious and extremely severe and should be met with extremely severe punishment. We trust in the wisdom of the court to recognize the full impact of these actions on all parties involved and to deliver a resolution that both acknowledges the depth of our loss and upholds the principles of justice upon which our faith now rests. Thank you for providing me the opportunity to share my perspective on this criminal murder. I now defer to your judgment on this murder case.
Thank you, sir, and thank you very much for being here today.
It's a very confusing family dynamic.
Well, I think when Mr. Droskowitz said it's been quite a roller coaster that got everybody here, I think that's part of the understatement as to how we got here. But I did preside over this trial for 2 weeks, and I was able to hear all the evidence that was presented by the state, as well as I was the judge when this case was originally negotiated in a settlement conference, and then Ms. Michaels wanted to withdraw that plea and proceed to trial. And the jury has ruled, and we all have to respect the decision of the jury. But I have to say, and I think Mr. Willette said it best, and as well as so did his wife, because one of the biggest concerns that I think we should all have as we deal with this is the fact that these children are going to be left without either one of their parents. And it's not any fault of theirs, it's not anything that they played a part in, but as well as everything that they had endured up to this point. And now, Ms. Michaels, based on your actions, they are going to be left without either one of their parents. Pursuant to the jury's verdict, you're going to be adjudicated guilty of first-degree murder with use of a deadly weapon. In addition to the $25 administrative assessment fee, your DNA was taken in 2022, so it's waived. The $3 DNA assessment fee, you're going to be ordered to pay $5,000 in restitution to victims of crime. You're going to be sentenced to 240 months to life in the Nevada Department of Corrections. There's going to be a consecutive 96 to 240 months in the Nevada Department of Corrections for the deadly weapon enhancement. And as of today, you have 780 days credit for time served.
Thank you.
Thank you.
Mr. Johnson, your office will be allowed to withdraw at this point. Mr. Brown?
How many months is 240 months?
Appellate counsel so that you can file the notice of appeal. Yes, you could put it.
Is that 20 years? Somebody do month math. You know we can't do it.
Thank you.
So she got 240 months for murder. The turn down this volume. I'm probably like telling you guys there. All right, so 20 years. Okay. She got 240 months. And then for the deadly weapon charge, I think she said concurrently. Oh, shit, I don't know. It's like 96 months. So that's strange. Interesting. And she didn't say anything about parole. So very interesting. How does the court reporter do her job? Could you imagine how fast she has to be? It's like, it's crazy. It's crazy. All right. So somebody will pull up how much time she actually got and whatever that all was. Because I don't know. Somebody can do the math on that. But before we go back to watching the Paul Caneiro hearing, let's talk a little bit about those victim impact statements, because one of the things that we were constantly wondering about is what happened to the two little girls that Johnathan and Devyn had together. And we didn't know. We just kind of assumed, because there wasn't really a lot of family around in Vegas, aside from Jonathan's mom and mom's boyfriend or stepdad, I don't remember, who Johnathan lived with. But we know that they didn't have the kids because they testified in the trial. So we weren't exactly sure where they went. Well, it turns out the two little girls went to Jonathan's father, who did the victim impact statement, and his wife, who was the first victim impact statement. And they said some very interesting things, especially the wife, right? She said that, well, they both said that the children were not seemed properly not taken care of, both how they dress, their hygiene, their social skills, their ability to listen. They sound like they were heathens, for a lack of a better word, but that's not their fault. They're just children. That falls on to the adults there. So 28 years is that, but was it concurrent or consecutive? I forget already. I should talk so fast. But so apparently these girls did not have clothes that fit, even though we saw that the house was a wreck. I mean, this was not surprising to hear about the girls, to be quite honest, based on the pictures we saw of the house. And she had the money because she lived in a nice ass house. But anywho, the stepmom did not have nice things to say about the rest of it. I'm assuming they don't live in Vegas, based on the father, James, saying, the traveling it took for court, all of that. They must not live in the area, I'm thinking. But they said that no one else in the family has really been around to help with the girls in any way, shape, or form, except for Devyn's sister, who happened to be in town and stopped by, which is very interesting. Devier just apparently fucked off. I don't think the stepmom likes him very much. She definitely had some disdain in her voice about Devier. So remember, Devier is Johnathan's son who married Devyn, and the girls would be his stepsisters, while he is the stepbrother / stepdad. What a mess. What a mess. So I found that to be interesting. They had to go through all of this foster stuff to be able to get the girls. So she said, the stepmom said, we had never even met these girls. So that's another reason why I think they live far away. They either live far away that they couldn't get visits, or Johnathan was estranged from his father and stepmom. I don't know. We didn't hear much about that relationship at all. So those are just assumptions, but they did seem older, and it's unfortunate that they have to raise their granddaughters who are still so young. Because it's not easy raising kids when you're older, but also like the traumatic kids. All right. I think we all agree that these kids were definitely exposed probably to lots of things before the murder even took place. Because Johnathan Willette, the victim, did have custody of the girls because there was child abuse charges. And so full custody went to him. And then he ended up letting Devyn have the girls over the summer. And then Johnathan was going to move in with Devyn and the girls, but not with his son / Devyn's new husband, who was supposed to move out. What a mess. Probably one of the weirdest family dynamics in a trial I've seen so far. So, I mean, I'm glad that the girls are with family, but it does bother me. Like his mom, Jonathan's mom, saw the girls all the time. So she didn't want to, or maybe she couldn't. I mean, I'm not going to shame anybody for, not taking two small children in. There could be a mirage of reasons why maybe she didn't qualify or anything like that. I don't want to say nobody cares, but I think that's interesting. That they ended up going with grandparents that they'd never met before. So, and listen, I know Devier was young when him and Devyn got together, but like, these are your half sisters and you're a grown ass man. I'm just sorry. I think you should step in to give your half sister some sense of normalcy, because you are the only immediate, like, you helped to raise them. And then you just kind of fucked off because you have a girlfriend in California who was at the trial. Remember that. Her and her family flew with him for him to give his testimony. I just, so much dysfunction. so much dysfunction. I'm not saying that I think Devier should have raised the girls. That is not what I'm saying. I don't think so at all. But you're not even going to like get a hold of people to see how they're doing or visit them or anything like that? Really? Okay. Okay. Well, that wraps up the sentencing of Devyn Michaels there. I'm going to change our little banner. We're going to finish out this Michael Caneiro hearing today, and then we're going to call it a wrap. Because we're learning lots of things that we can expect for the trial that starts next week that we're covering. So we're going to continue. Oh, that's not even the right one. Because we'll know more about the trial when it starts this week. So we're going to do that. But whew, that was a crazy trial for sure. She didn't really have as much motive, I felt like Devier did. But I mean, sometimes people don't really have much of one. But anywho. All right, let's get back to this pretrial hearing we were listening to previously. Add to stage. There we go. Let me get this one. There we go. Yeah. I'm going to go use the bathroom real quick while we pick up.
We're aware of what the court said. If we can move for reconsideration by providing a small number of phone calls that we intended to use without consideration of others that would
how much time do you need to turn it over? The numbers that you're going to call
by Friday.
Done. So by Friday, which is August 15th, by noon, that they should be turned over. Any objections should be responded to by August 22nd, 1 week later by noon. If there's anything that needs to be addressed by the court, notify the court by August 25th at noon. And then I'll figure out a return date if I need to. Hopefully we don't need that.
Yeah, Judge, it's not a lot. It's not going to be a lot.
Okay. All right. As it relates to, now we'll go into the other ones. Body worn cameras, all that, we're all good with?
Yes, I just wanted to confirm, just for my recollection, I know that Ms. Mastalone had sent over certain changes that she wanted to make, which we agreed with. And I know that we put in place having them made. I believe they've been provided, but I just wanted to confirm that.
Yes, they have. Those transcripts were provided. The state did indicate previously that it had agreed with all of the defense's proposed changes. In all candidness, Judge, I haven't reviewed those line by line. I'm trusting that they incorporated them, but I will do so, before in the near future just to be sure.
Okay. Are there any other transcripts or anything else that I haven't mentioned? Because I don't want any issues coming up.
No, there's not. Nothing that hasn't been discussed previously. Everything's been turned on.
Ms. Massalone's about to stand up, so maybe.
No, Judge, I was just going to also note we did also receive redacted body worn camera transcripts as well.
Okay.
Those were also provided.
And were you comfortable with those?
We're still reviewing those, Judge.
Same timeline if there's an issue.
No problem.
Bless you. Yeah. All right. Okay, I did receive the proposed witness list, which is approximately 8 pages long of witnesses. This includes all witnesses, correct? Both the state and the defense?
Yes, Judge, with the only caveat being that if we discover along the way that there's one person we inadvertently missed, we are going to bring that to the court's attention as soon as possible. But yes, I did add the defense witnesses. I didn't delineate state from defense. So that's that.
Here's the thing. I understand with the amount of the complexity of this case that you maybe have missed someone. But when by September 8th, when that rolls around, you got whatever it is, whoever's on this list, that's it.
That's more than fair, Judge. And I don't expect that to become some sort of issue. I just wanted to kind of protect myself.
I understand.
In advance. And I also do expect that by September 8th or before, I may be able to give you a more manageable list that you can slide into that jury booklet.
Right.
I don't.
Which we do need. Yeah.
I understand. I'm just, we're still working through some of this stuff. And also there's names on there that like just maybe heard. So I think it's appropriate. Like we've discussed this previously on the record. So sure.
Ms. Sloan, do you disagree with anything that was said, or is there anything about the witness list that the defense objects to?
No, Judge, no.
All right. This will be the witness list to the state. Thank you for the other list that I had asked for. So I have a basic understanding just in going through voir dire. All issues for the defendant's clothing, has that been settled and taken care of? Is there any issues that I need to know about or get involved in?
Not at this time, Judge. We've been in contact with Lieutenant Hansen. He was on vacation last week, so now that I think he came back yesterday, so we're in the process of coordinating with him.
Okay. Any issues, please supply them to me immediately so I can get assistance to you in any way that you need it. Any other security concerns that I need to know about? I know I addressed this before and everyone said no. Just want to give everyone another opportunity. Is there anything that the court should be aware of that I'm not aware of right now as it relates to informing the sheriff's department?
Not that the state could think of, Judge.
Okay.
No, Judge, I was going to ask at some point if we could reserve this front row for family members. Just, I don't know, something for the court to think about.
It's going to be that side.
Okay, yeah, that's perfectly fine, Judge. I was just hoping that if we knew the designated area ahead of time, we could work that out.
Yeah, you mean who gets the first row and who gets the second row? When I reserve it?
Either way is fine, Judge.
Yeah, I'll let you know. Yep, no problem. Other than that, I've indicated that when we got to today, all discovery has ended. I'm confirming there's no other discovery related issues that are outstanding. We're not going to have any more discovery except for if a witness that you're prepping that may say something that you have the continuing obligation to turn over. But other than that, everything that you have has been turned over and we don't have any issues.
Yeah, Judge, I don't foresee any issues, Judge. I mean, we've been providing discovery for years now. And the majority of that, which has been turned over more recently, is as a result of further inquiries and, things that maybe they pointed out that we didn't realize weren't provided. We've tried to do our due diligence. We've assisted the defense as best we can. We've also, I know it's a little bit of a different issue. We've already met twice in our evidence vault with the defense, meeting with them again today. So we're doing everything we can to work professionally with counsel to make sure that, anything they need and vice versa.
Okay. From the defense?
I agree with that, Judge. We've met numerous times and had the opportunity to review evidence in this case. The state's been very accommodating in that regard. I do appreciate the court's directive that no additional discovery be provided at this time. As the court knows, with respect to the preclusion of the media or the electronic communications motion, that was a little bit of a hassle, but it's been worked out. So I would just, again, ask that be it.
And there's no requests outstanding? Any discovery requests that you haven't received the answer of, we don't have it, it doesn't exist, or we've already turned over? Is there anything else out there that I need to know about?
There's nothing outstanding. And the defense is meeting with the state one last time today to continue reviewing the evidence.
The physical evidence.
Correct.
Okay.
And there's been photographs that have been taken, and those will be supplied to the state. Like, they haven't been taken yet, the ones from today. Those are just photos of the evidence that we're looking at. And then there's a couple other photos, but other than that, Judge, yes, discovery is complete.
Okay. Speaking of photos, let's just do that now so we don't have to come back to it. Mr. Decker, I assume that the state will have some form of a photo book in this case of what you're going to be using. Do you have a timeline of when you're going to turn that over to the defense and to the court so that if there are any issues or if Ms. Mastalone wants to add some photos to it, we can kind of do it all at once before the trial starts?
I'm glad they're
about that
taking care of this stuff way in advance.
I've certainly thought about the photo book, Judge. It will be marked S1. The only thing that I'm working on is obviously putting it together. I have different portions of it put together. For instance, autopsy photos. For instance, photos from 27 Tilton. We have the arson photos that have already been used, some of the Watson stuff. So I'm just deciding whether or not it's going to be set up from a 27 Tilton photos 1 through 50, 15 Willowbrook, 51 through 80 or 1 through 30, depending on just trying to finalize that. But we are still trying to finalize certain pictures. That being said, my intention would normally have been to provide it prior to jury selection to the court and to the defense.
That's fine. What we'll do is that if you can supply it to the court and to the defense, if you have it by September 5th, which is the Friday before, I would appreciate that. What I would do is, Ms. Mastalone, is then that following Friday, because no photos would be going up on the screen in that first week because we're going to be picking the jury anyway, that if you had any issues with particular photos, you can let me know, and then I'll address them on the record, and we can go from there. I would also suggest, and tell me, Mr. Decker, if you're doing it a different way, that if you have certain photos, instead of having to go and try to upload them or try to get them on a computer or whatever it is, if you want to add those photos into the overall PowerPoint, you can do that. Now, I have experience in the past where attorneys say, well, I don't want to give it to them yet because I don't want them to know what I'm going to ask questions about. That could be your way of handling things. I really don't care. Whatever you want to do is fine. But I'm just giving you that option. I'm sure Mr. Decker would accommodate that request so that things would run a little bit more smoothly. All right.
Thank you.
We would.
Judge. One other thing that does remind me that I haven't received it from the state, and vice versa. We've sort of talked about it, is just, I know both parties might intend to use some Google Maps photos with certain witnesses, maybe just to show your house is located here and this is where 15 Willowbrook is, or this is, so I don't have any issue with the state using the Google Map photos. And so I don't need them super ahead of time. And I would just ask that the state accommodate the same. I don't have all of my Google Map photos just yet.
Okay.
Yeah, that's fine.
All right. That's fine.
We did talk about that, Judge.
I know we have used a couple during the Watson hearing, I believe.
Yeah.
But yeah, I would probably use fresh ones or that sort of.
Are you going to be, just so that I know, you're going to be using Google Maps from a 2018 version? So it looks like it did then, or is it whatever it is now that you'll be using? I don't really care. I just want to, just so that I know that if I have anything I got to deal with.
It's a fair question. I will give it some thought and let the board know it's fair. It's fair. I think certain places, depending on what they are, they look the same.
Right.
Certain places, they're obviously different. If we were to show an overhead map of 15 Willowbrook right now, there's not a house there.
Right.
So, yeah, but it's a fair question.
Okay.
And the ones I anticipate, Judge, I can let the court know, the ones I have, when you go to, Google Maps or satellite, Google Earth, you can change the date. And I think the closest to November 2018 was it's either June or September 2018. It's very close. So I think some of mine are going to be that. I have no objection to the state using ones that are updated if the foundation is laid, this was taken later and this is changed or something.
Okay. All right. Perfect. All right. All right, so the photo book 9/5 by noon. Okay. All right, now let's talk about the issue of the eliminate submissions
Or as
that were
Angie
submitted
says,
by the
motion
defense
Llama.
on August the 8th.
I love it.
The first issue that I'll discuss is one that I think is already taken care of, is the request for voir dire dealing with the gun issue. Do we all agree that that request has been addressed? There's nothing further that needs to be done based upon the additional open-ended question.
We agree with that. It's been addressed.
Okay.
I would just renew the objection that I would ask it to be asked at sidebar, but that's all.
Okay. All right. And that's noted. All right. So that one is taken care of. Then the next one we'll talk about is to preclude electronic communications. So when the court made a ruling on, I believe it was August the 5th, as it relates to certain states' evidence, that it was going to be relying upon communications between the defendant and the victim, Keith Caneiro. The court made a finding that conversations that occurred on April the 10th and
I think
April
there's
the
still going to
11th,
be a lot of sidebars, Tracy.
those conversations would, 2018, they would be admitted. And then also dates in September, dates in November, and then the night before this actual incident. The court also had made a finding earlier back in the early part of July. It was around July 10th. I don't have the exact date in front of me. It was a motion by the defense to bar certain evidence from being admitted. It's a suppression motion based upon State versus Missick. The court agreed with the defense that the information that was taken from the defendant's phone should be limited only to the dates surrounding the actual offense based upon the affidavits that were supplied to the reviewing court at the time, which was November 19th and November 20th, 2018. In that decision, I had indicated that the state would not be able to use evidence outside of those two dates from Mr. Caneiro's phone, that they would have to find those communications that they wanted to rely upon based upon another independent source. The state has, when the court made this ruling on August the 5th, the defense had brought up the issue that some of the communications that were relied upon by the state in that motion that they're not located in any other area in the discovery. I had informed the state that they were to find that information, or if they could not find that information, that the court's decision obviously would have to be altered as it relates to these items of evidence. We had a conference this morning. It is my understanding now that there are certain communications that were not present in any other area of the discovery. And I'll allow the state to put that on the record so that we can flesh it out and make sure that the record is clear. And then we're going to come up with a resolution on how that will be documented. The court had talked about a consent order that both sides agree of what you could use, but I'll allow Ms. Wallace to explain this, and then we'll come up with that conclusion. Go ahead, Ms. Wallace.
Thank you, Your Honor. That's correct. There were text message communications on April 10th and the 11th, and then September 6th that were not located anywhere except on the suppressed phone. So the state will not be using those, and I can submit to the court. I think Your Honor wanted the specifics of what they were.
Yeah.
I can submit that.
So anything that is not within your brief, or that was in your brief that's not within that discovery, that should be precluded and from any testimony in this particular case because you don't have an independent source. Ms. Messalone, you want to address any of that other than what I just said?
Judge, I would just agree with that. I think we can accomplish it by way of a consent order that just, the April 10th, we could say, for example, the parties agree that the text messages that the state discusses that occurred on April 10th, 11th, and September 6th outlined on the respective pages in their June 13th brief are precluded from use or admission at trial. And then the parties agree that the remaining 3 conversations that are listed in the defense's original certification and updated letter, which is September 13th, September 17th, and November 5th, that those are admissible. The concern that I have, Judge, is
some of the April is there, correct?
not the text messages.
Not the text messages,
I think
but
the state
other
referenced
email.
an email.
Yeah.
Right, but the defense is never challenging the emails. The defense is only challenging the presence of text and electronic communications.
Okay.
Not email. Because we were able to discern the emails from the data that we originally had.
Okay.
I understand that the state is indicating, like, for example, I think we discussed in chambers, there might be something over the summer, and it was sort of summarized as facts. It wasn't clear, like, exactly, at least not to the defense, exactly how they were intending to get that in. So if those are specific text communications, I would just ask that the state, identify them, or at the very least, double check that they're there and provide a certification that they're there, because it's very tedious for the defense to have now been presented. Now we have access to this program that the state gave us yesterday, which now we can pull up these conversations and we have to go through them. And I want to just, for the court's edification, and put a footnote in my letter, like, it's not like when you go through a phone extraction and you see a whole conversation back and forth. It's not like you're reading it in the little speech bubbles, how we've seen. This is more unique. And what it is the state provided us with a program yesterday where it filters the data, and it kind of looks like how Outlook looks like, how an email, an email platform. And so each text message appears as if it's like its own email, right? And so it's not a back and forth. And the problem, Judge, is like also the text messages don't say to whom they are being sent. There's no identifier. It just says Keith is who it's from, and then like the message itself. So what the state demonstrated to us and what they told us and what we were able to discern yesterday evening is that what you can see is that there's messages from Keith to an unknown, but then there's messages received by Keith from, for example, the phone number assigned to Mr. Caneiro, right? So in context, it's like a message from Keith to an unknown that says, I'm just as an example, like, what time are we having lunch, right? And then the response from Mr. Caneiro would be, how's noon, right? So like if you read them back and forth and they're actually in consecutive order, it's like clear, it's Keith, it's Paul, it's Keith, it's Paul. We can discern that information. My concern comes into play with, there are other areas where Keith's texting multiple people at once. So you can't actually fully tell, who the messages are to if it's like kind of out of context. So, with, for example, these over the summer messages, I don't know if it's as clear as the ones that we're conceding you can put into context.
I feel like that would be confusing for the jury. Are these
conversations continuous, or is Keith texting 5 people at once and every 5th message is to Paul? That's what we're surmising. So that's why I think it's a little bit more involved. And I think if the state can provide it ahead of time, at least we'd have the ability to double check ourselves. Or if they accompany it with a certification, we could feel comfortable, like we don't need to double check it. They're saying it's there and that it's discernible.
Okay. Ms. Wallace?
Judge, the state will provide the order requested. We'll come up with a consent order like we discussed. I think it's my understanding that what's being objected to and what the state is agreeing you're not going to use are those April 10th, 11th, and the 6th communications.
September 6th.
I'm sorry, September 6th communications. As far as things over the summer, I don't even anticipate really using any of that. I included that in the brief, but I don't foresee that. It's really.
Well, I ruled on a part of it, so if you decide not to use it, that's fine. Whatever you want to do, it's your case. Just inform the defense that you're not going to use it. So then at least the record will be clear as to the fact that I've permitted you to use something and then you decided not to use it. That's fine.
But we'll come up with that consent order. We have to meet on other things like we discussed today anyway. And as far as the layout of that council was discussing of the actual, what the screen would look like, it's my understanding that with respect to what I memorialized in my brief, that what is there is not being objected to based on content, but the defense might request to have maybe like the full conversation in which the state would not object to.
Okay. So
just to the record's clear, we did object, but Your Honor ruled that it's admissible. You know, they filed the motion to admit under 4.4b and intrinsic. We opposed it. The court ruled that they're admissible. So we're
well aware of
obviously back to
68
that.
pages of an opinion. I got it.
Oh, 68
So
pages.
the court's not going to issue an order one way or another on this in limine motion. It's going to wait to get a consent order from you. That consent order should have in it, Ms. Wallace, please, discussing this in limine motion. As a result of the in limine motion, we have consented and whatever it's going to be. Okay. I will do an order for the voir dire of the gun so that you have an order as it relates to that in limine motion of how I addressed it. Okay.
Thank you, Your Honor. Thank you. That's my motion.
All right. So the next issue, next in limine motion was to preclude autopsy and graphic photos. This morning, the state provided the court with its photos. We've had an opportunity to discuss it briefly. We're not going to do these graphic photos in open court at this point in time. What I have asked counsel to do is to review these together. They're going to be together all day today. And they are to see if they can come up with some agreement. I've already given some preliminary thoughts on certain photos that I would have concerns with, and also understanding that the state may need certain photos for purposes of proving its case for each one of the victims that I would be inclined to allow. However, the defense has spoken about the potential of maybe stipulating to certain things. And if that's the case, what I'm asking the parties to do is to come up with a stipulation that both sides agree to as it relates to these photos. I don't care who reads it one way or another. But again, there will be 2 copies of the stipulation, one that will be signed by all parties and the defendant, and one that would just be marked and sent into the jury room after the case went to the jury. But I'm going to allow counsel, both sides, if they want to put any arguments on the record, to be able to do that now as it relates to the photos.
Judge, I'll be brief. I think we discussed this in chambers. I don't want to get too specific out here. I understand that some of these photographs are graphic. Unfortunately, that's the hand that we're dealt with respect to the horrific nature of these deaths. In particular, most likely or most probably poignantly with Sophia and Jennifer Caneiro, given the state of the bodies. We try to be guided accordingly. I understand that there was objections to certain photos. I understand they're going to argue that we have to think about the jurors and the reaction they may have. I get that. I've spent a lot of time looking at autopsy photos that I don't want to look at, quite frankly, but I looked at. And unfortunately, it's part of doing our job to prove the cause and manner of the death, whether they are, challenging it or not. I'm not going to get into it further. I
think it's
I looked to the court.
We
looked to the court this morning in chambers for some insight, because I am realistic in the fact that I don't want to go too far if it's not wholly necessary. Therefore, we will look to pare this down in conjunction with a potential stipulation. I have given some thought to being able to say, for instance, in summation, that we didn't show you this because, quite frankly, it wouldn't be fair. It's so bad that, these deaths, etc. So I'll give it some thought. we'll discuss further today, and be guided accordingly. And if we can come to a resolution, I hope we certainly can.
We'll have the same time frame that we had for the other issues that we discussed, that by, if you come up with something, it would be due by August 15th together collectively. If you don't come up with something, I want the objections by then, and then I'll figure out a day to hear it after that.
Also,
So it'll be
especially
August
for
15th
medical
if there is
examiner,
objection. But Ms. Massalone,
You know,
I had indicated to you in
Not
chambers that I would give you the
everybody
opportunity to object to these on the
knows
record,
anatomy and stuff.
even if there is some ability to be able to come to some stipulation
Apparently
that
the
both sides
monitors
agree
are
to. Go ahead.
Thank you, Judge.
horrific,
Just
I
to
guess.
clarify, did Your Honor mean August 22nd as
No.
in next Friday, or Your Honor?
No,
meant
because I'm gonna need more time.
Okay.
So I'm gonna give you to the 15th as it relates to this one.
Thank you, Judge. So yes, just with the qualifier that we did have the opportunity to conference it, and the parties have indicated that we're amenable to meeting and conferring and see if we can resolve this with a stipulation. I just in the event that we are unable to agree, or if the state beyond the stipulation is still seeking to admit certain photos, which I understand also may be the case, I just want to place the objection on the record. So I appreciate the court's indulgence with that. So yesterday afternoon, Judge, the defense did receive 25 pages worth of either autopsy or on-scene photographs that are graphic in nature. They amount to 50 total photographs. I think it's actually pretty evident. I would say that the defense objects to a large majority of these as being either not relevant or unduly prejudicial. And I'll rely on the case law that I provided in my brief. I know the court's well aware of it. But I do just want to highlight, I think the court really, part of its gatekeeping obligation here is to assess what is the actual purpose of each of these photos. And that's where the defense just wanted to take the time to highlight a couple of things. One, the defense doesn't challenge the cause and manner of death in this case. And nor, I know in the states
Of any of the victims.
of any of the victims, exactly. Tragically, the victims in this case are deceased as a result of gunshot wounds, stab wounds, and or smoke inhalation. So that's not contested. The angles of the stab wounds are not contested, as they are identified in the ME reports. Again, I think the photos speak for themselves. How many, as well as the autopsy report. So how many bullet wounds there are, or how many stab wounds there are per particular victim, not contested. We did have the pretrial hearing with regard to the arson, so I understand why the state, in its response brief, was expressed a concern, like, well, what if the defense is challenging the time of death of the victims? And I clarified, we're not challenging the time of death. There's a lot of circumstantial evidence in this case that can lead any reasonable person to arrive at the conclusion that the murders or deaths occurred during a specific time frame. Again, we're not challenging that. So I think, and I also indicated that, there's a witness that the defense is not going to call. That's, related to that, tangentially related to that issue. So if that assists the state or the court at all as well. That was Mr. Wood. So the point is, Judge, is like when we're looking at 50 photographs, right? And I had suggested, I know it's not the preferred method, but by the court perhaps, but the defense would suggest potentially a 104 hearing where even if it occurs right before testimony, where the ME gets on the stand and says, I need photo number 1 because of this reason, right? And then reason by reason, like, well, is this something the defense is contesting? Because if the defense is not contesting this, or if the defense concedes this, or if the defense can stipulate to this, why do we need the graphic photo? I think it was related to a different issue, but oftentimes the analysis is like, what is the least prejudicial means through which the jury can learn this information. And if it's just,
Isn't there going to be an issue as it relates to one of the defense experts in a report that was supplied as it relates to the knife wound injuries, that there may be some relevance as it relates to that, or no?
Judge, I don't think so, and I can discuss that with the state as well. Because
There's photos in that report, right?
Oh, right. But I also indicated in my reply letter, that if that expert testifies, he is not by any means relying on the photos in his report. He provided a trial presentation slideshow that only has 6 photos, and they're just sort of zoomed in on a little tiny wound. It's not.
I understand, but if that happens, then the state would have the ability to respond to that with photos that they feel may be responsive to that. So I'm just saying to you that it's not just in that vacuum that you're talking about, that it may become more relevant also during the course of the case. So I may have to make a determination first by saying certain things are in, certain things are out, but may have to readdress them depending on what happens.
And I think that's fair, Judge. I think the court's ruling with respect to the state's case in chief is separate and apart from the defense potentially opened the door to allowing photographs in. I think that's a separate analysis. Yeah. But with respect to only the state's case in chief, and let's assume for a moment the defense isn't even going to call that witness. If we're looking at it through that lens, I think that there should be, it should be placed on the record. There should be a mechanism where each and every objection is noted, as far as, again, the ME explaining, like, I need this photo to show XYZ, and the defense saying, we don't dispute XYZ. So we would ask that the court permit the ME to simply testify to these facts, or explain the facts to the jury, or explain, the condition of the decedent upon receipt. Like, those are things that can be explained via testimony, particularly in instances where the defense isn't disputing the information. So with that said, Judge, I think another part of the court's analysis here that's significant is, and I provided 2 articles. Did the court have an opportunity? Does the court like a hard copy?
I have them.
Okay. Does the state have them?
Yes.
Okay. So, Judge, I just want to highlight a couple of things, because when we make these arguments, right, it's unduly prejudicial. It's very vague, and it's almost abstract. And I think what these articles help identify.
I read the New York Times article before you even supplied it to me, so I know exactly what it says. You don't have to reiterate it unless you feel a need.
Just as a broader principle, I think what both articles highlight is what the prejudice specifically is, right? It's not just like prejudice. It's that these jurors who observe graphic photographs can very much ultimately, it could result in not only trauma, but also it being a basis that serves to create a bias against the defense. And I think that that's what these are, particularly the law review article highlights, is that arousing negative emotions in jurors is not just an unfortunate but harmless byproduct of presenting evidence of certain injuries. Experiencing intense negative emotion can bias how people process information and to make decisions. Gruesome photographic evidence of, and they're referring to plaintiff's injuries, but let's say a victim's injury is particularly likely to rouse anger, which people tend to feel when they see an act of harm against someone that they perceive to be intentional, and disgust, which people tend to feel when they see a violation of a body. Psychological experiments have demonstrated that feeling anger and disgust can create a need to blame and punish someone to right the scales of justice for the harm that they have witnessed. And the combination of anger and disgust is particularly powerful. And they go on to cite some studies where they had, a mock trial with mock jurors, and group A only heard a description of the injuries versus group B who saw the photographs. And essentially, this article recaps how the result of those studies demonstrated that the people who were shown the photographs not only experienced like more of a disgusted response and therefore that they also experienced more bias when they were more inclined to convict or more inclined to view evidence through a different perspective, which was that it was not as objective to hearing out the defense. And so a lot of times their perception can be skewed in favor of conviction or in favor of guilt just by virtue of seeing the photo. And it's not conscious, it's not intentional, it's just human nature that, as Mr. Decker indicated, like none of us want to see these photos. And certainly, you know, at the very least, this is our job. The jurors, although technically it's their civic duty and their job, they can't pick and choose their trials. So if they're not emotionally prepared or psychologically prepared to see graphic photographs, it could not only harm the jurors, but also obviously then impact the bias toward the defense, whether it's conscious or not. So I think that the articles, I'll just place the titles on the record. It's the impact of gruesome photographs on mock jurors, emotional responses and decision making.
Me and Bobby
it
are
says
like,
in a civil case by DePaul University, DePaul Law Review, Volume 69, Issue 2, Winter 2020. But again, although it's this particular article discusses a civil case, which the mock experiment is like the second half of the article. The first half of the article talks about how most of the case studies surround criminal cases and it recaps those. And that's what I'm specifically referring to. And the New York Times article is titled, "After a Grisly Trial, Jurors Are Left with Mental Scars and Few Resources." So I think, Judge,
I mean, the resources are what the problem is.
In light of the combined issues here, which is that we're dealing with an exceptional case here. We have not just one, not just two, not just three, but we have 4 victims, 2 of which are young children. And the injuries are particularly egregious, right? So there's multiple forms of injuries here. And when you combine all of those things, I think the heightened level of prejudice is exceptional in this case. That combined with B, the fact that the defense is not disputing cause, manner, method of death or time, creates a scenario where this court, I think, has to really carefully assess whether each individual photograph is actually necessary.
I'll do a 401 and a 403 analysis for each one,
Thank you, Judge.
if necessary. For the record, we're going to mark what the state has proposed. It's 25 pages. There's 2 pictures on each page, so it's a total of 50 pictures. We'll mark that as S1 for this particular in limine motion, so the record is clear as
By the way,
to
we only need 2 more followers on Twitch
what
to
photos
reach
we're
our
talking about.
follower
If you come
goal.
to limit those photos, Mr. Decker, you can give me a new version, and I would mark that as S1A or 1, 2, or 2, whatever. And we'll go from there. All right. So that motion will be held for now until such time as I hear from everyone on the 15th. The next request is for a witness to testify outside of the media presence.
Why?
That's a defense in limine motion. So I believe that's going to be heard on the papers, but Ms. Massalone, if there's anything that you want to put on the record, I'll give you the opportunity to do that now.
I have nothing to add, Judge. Thank you.
Damn it.
And the state took no position. The court will do some more research on that particular issue before making
It's not because they're a
its final
minor. Remember, no
determination.
minors are testifying.
Looking to get that opinion out either by Friday of this week. If not by Friday, then definitely by the beginning of next week, so everyone will know. I also want to point out that before I go to the other motion, is that I received notice from the defense that they are withdrawing their motion to preclude certain financial motive evidence that they filed in this particular case, and they're also withdrawing their motion to preclude Kimberly Patton's testimony due to the fact that the state has supplied expert reports, 2 different expert reports to deal with the 2 issues that were of concern to the defense. Am I correct?
Interesting.
That these are being withdrawn?
That's accurate, Judge.
Okay. And for the state, you've turned over CVs, the reports, everything has been turned over, correct?
That's correct for both, yes.
And Ms. Mastalone, you have received those and had an opportunity to look at them, correct?
That's accurate, Judge.
All right, next. And I should point out, with all of it, every time that I ask about this discovery issues that they've been turned over, Ms. Mastalone, you've also turned those over to Mr. Caneiro, so he's had the opportunity to look at them also.
Of course, Judge.
Okay. All right, the next issue is the defense has requested the court to reconsider the motion for change of venue as it relates to an opinion that this court has already ruled back on April 4th, 2025. In a written opinion, the court denied the defendant's motion to change venue, which was originally filed on March the 7th, 2025. At that point in time, the court had indicated that the defendant had not met its burden under Rule 3:14-2 and controlling precedent to show a clear and convincing proof that a fair and impartial trial could not be held in Monmouth County. The defendant now moves for reconsideration. I should point out, as I indicated before, that the defendant had filed this motion on March 7th. And at that time, the defendant moved for change of venue, citing cumulative local publicity. The Asbury Park Press concentrated readership in Monmouth and Ocean County, and the prevalence of hostile online commentary. The state opposed that motion, arguing that the coverage was factual and that the voir dire would suffice to ensure impartiality. On April 4th, this court denied the defendant's motion in a 53-page written opinion,
disappointed by the lack of
including that
accents.
1, most coverage was fact-based and neutral. 2, no torrent publicity or carnival-like atmosphere existed. 3, social media commentary was not competent evidence of community-wide prejudice. And 4, that the comprehensive voir dire would adequately safeguard defendant's right to an impartial jury. On August the 7th, 2025, the defendant filed the present motion for reconsideration, attaching exhibits claiming to show 65 new items of news coverage since April the 4th, 2025. State opposed the defendant's motion in a brief on August the 10th, 2025. Defendant's argument now incorporated everything that was in the original March 7th, 2025 brief, and indicated that these 65 additional items of coverage since April, consisting mostly of Asbury Park Press articles, other news outlet reporting, and online commentary, the court should reconsider its decision of April 2025. Defendant emphasized that the volume of news coverage occurred in just 4 months, which he claims marks a significant shift from the court's finding of the peak coverage that occurred in 2019. Defendant argued that the most recent coverage has reinforced community awareness and hostility, particularly given APP's concentrated local readership. When I say APP, I'm talking about the Asbury Park Press. The defendant further asserts that much of the recent coverage was triggered by defense filed motion, but contends that the defendant should not be penalized for exercising its rights. He maintains that online and social media commentary remains inflammatory and reflective of local sentiment. On the merits, the defendant renews his claim for presumed prejudice under Harris and Marshall, arguing that the nature, frequency, and distribution of publicity now meets the threshold for a venue change. In the alternative, he requests that the court reserve decision until voir dire, at which point a finding of actual prejudice could be made if juror questioning reveals bias. The state, in its response to this August 7th submission, relies on its March 21st, 2025 written submission and oral argument in response to the defendant's original motion. It argues that the increased volume of coverage since April 4th, 2025 is unsurprising given the number of recent motions litigated, but that the coverage remains factual and does not contain name calling or opinion pieces such as those found prejudicial in State versus Harris. According to the state, the recent articles merely recount what each side argued and what the court decided. None constitute a torrent of publicity that creates a carnival-like setting or a barrage of inflammatory reporting.
I mean, there are comments made
as
on the
noted in
internet by
State
people.
versus
That
Nelson.
doesn't mean just local people.
The state further notes that some headlines could be viewed as favorable to the defendant, covering the defendant's successful motions. Regarding social media commentary, the state argues that presuming hostility in the entire jury pool based on such comments would be premature and speculative. The state concludes that voir dire is the proper method to address any potential prejudice, and that the court may revisit the issue if jury selection reveals a realistic likelihood of bias. I tried to outline the arguments. If counsel needs to be heard further, I'll give you a chance to do that now. Ms. Mastalone, this is your motion on behalf of your client, so the floor is yours. I'm just asking you not to reiterate your brief.
Because that's 10 weeks.
Yes, Judge, just very briefly. And I just want to highlight,
Probably
you know,
not.
when we talk about the pretrial publicity and the prejudice, it doesn't have to always be super negative prejudice name calling type reporting. I think what the court can also consider, which is more what we have here as well. I know I previously made the arguments about how the social media commentary can come into play with the negative publicity and how people see the social media posting and comments online. And I don't need to reiterate that argument. The court's aware of it. But with respect to the media outlets themselves, fact-based and neutral reporting can still be problematic. And here's why. Because many of these headlines, if you read through them, reveal evidence that is either going to be admitted at trial or that is not going to be admitted at trial. And they are both equally, if not unequally, they're both problematic. And the issue is that when jurors already have a sense of the evidence that is to come, or if they have knowledge of evidence that exists that they don't end up seeing at the trial, it creates a clear prejudice for the defense. I mean, the jurors, we know, should be as close to clean slates as possible. I know the case law says it doesn't have to be like completely clean. They can have a little bit of knowledge, but there's a difference between having some familiarity with the fact that this case exists and to know, testimony likely to be elicited when Paul Caneiro goes on trial and they go in, the article goes into detail about certain testimony. Pre-trial hearings provide sneak peek of Paul Caneiro's trial in this case. Surveillance video shows, and they're playing surveillance. There's surveillance.
Do you agree
videos.
that some of your exhibits are actually duplicative? If you actually look at them, do you agree that some of them are duplicative?
As far as like the headline itself, yes, the medium is different. So some of it is like an Asbury Park article. Some of it is Asbury Park Press posting on Facebook. Some of it is Asbury Park posting on Twitter or
saying the same exact thing, though. You would agree, right?
Yes, exactly. It's just that it reaches a wider audience the more mediums that it's posted on. So maybe someone doesn't subscribe, but they see it on Facebook, or they're not on Facebook, but they're on Instagram or Twitter. So that was the purpose of showing, yes, so that the headlines themselves are duplicative, but it's separate content as far as the audience base.
Well, it's not separate content. You're saying that it's separate base that will read it, but it's not separate content. It's the same content, or taking blurbs of certain content. Correct?
When I say content, I was referring to the medium itself. It's separate mediums. Okay. The content of the information is the same, yes. But nevertheless, Judge, we're talking about surveillance videos and sneak peeks and evidence examined and motive evidence, alleged motive evidence, life insurance policy evidence. I mean, all of these things are evidence that jurors should not have any knowledge of prior to sitting on this case. And there's just, I mean, that's the whole point of the motion, right? Is like, we're not saying that there's not some needles in a haystack here that maybe have no knowledge of this case or that have very limited knowledge of this case. But the purpose of highlighting, like, yes, these are repeated headlines, but here are all of the vast mediums that they're published on. And so they're reaching a wide audience base concentrated here in Monmouth County. And there's a concern that many of our jurors are going to come not only with this knowledge that is heightened in this case that they shouldn't have if they're sitting on the jury, but how that knowledge is going to cause them to prejudge this case or prejudge Mr. Caneiro, again, whether intentional or unintentional or conscious or subconscious.
Outside their courtroom. You're fine.
Beyond that, Judge, what is extra concerning are all of the headlines that highlight the suppression of evidence in this case. So, no juror wants to feel that evidence is being hidden from them or that they're not having access to all of the information. And if there's a wide reader base of the Asbury Park Press combined with the people that see it on social media, on the various platforms, there's a concern that, jurors are going to have that in the back of their mind or have information.
All of your arguments are making a lot of assumptions, aren't they? Under the circumstances, and also where we are today is really not different than where we were in April. We have to at least have voir dire, that searching voir dire, then we're going to know. So my concern is that, and I know you had indicated that the court could hold off on this and wait, but the court's position as it relates to where we are today is that the court, understanding its obligations to make sure that Mr. Caneiro has a fair trial and understanding what I've ruled on already, that if I find prejudice, actual prejudice at any point in time, I won't need either party to tell me that there's actual prejudice. I will do it sua sponte. I can tell you that directly right now.
Oh.
So I understand what your arguments that you're making. My concern is that we are again assuming certain things because we don't know until they show up, until they start answering us. Then we will know how wide ranging this is and how much people may care. They may have read something in 2018. They may not have they may have stopped getting the paper after COVID. Who knows? Or they may have stopped reading online after COVID. Who knows? So I hear your arguments. I don't know if we're in a different position today than we were.
The reason why I would submit we are in a different position, Judge, is simply because motions have been filed. As has been placed repeatedly on the record that up until more recently, no motions have been filed. Obviously, there's a change of counsel.
It seems like this judge will only let them ramble for so long, and then he's like, "Nope,
is
we're done."
Coming from clearly, and it's unfortunately right before the trial is about to begin. I agree, Judge, we are assuming things, but I think that's the whole point of the presumed prejudice, right? It's not like we have to come prepared to show presumed prejudice. That's why it's distinct from actual prejudice, because we don't have data. We just have all of this information that could possibly, if the defense were to meet the standard, demonstrate to the court that, you know what, there's just so much going on here. We can presume or assume that the prejudice has met that threshold. So that's the argument, Judge, and I understand the court is aware of it.
Okay, great. State going to respond.
Just very briefly, Judge, the state would reply on previous submissions. The court outlined them very accurately. Just in response to the defense's arguments, I would note that, in terms of any prejudice more recently and overall, I'm just looking at the voir dire here. There are specific questions in here about that. And they will be asked those questions as the court indicated. So at this point, it's the state's position that any presumed prejudice is premature.
The defense motion as it relates to for reconsideration, it's going to be denied for two different reasons. One will be for procedural grounds. It's outside the time frame, but it also will be denied based upon the merits of the argument. You'll have an actual written opinion today that will provide the reasons for the court's decision. And here's what I will say. is that, I just said it to Ms. Mastalone, if this court will be analyzing each and every witness that comes in here as to, each and every juror, prospective juror that comes in here. If the court finds that there's actual prejudice, that there is some pattern of that in this particular case, this court will, at that point in time, address it with the attorneys. Otherwise, this court has decided this motion. It decided it again today.
Than other judges,
and this court feels that if there's anything further that it needs, it will address it when
Are there different
the appropriate time comes. So with that being said, you'll get an order and an opinion today denying the reconsideration. All right. The next issue that is outstanding is this wasn't a written submission, but it was orally brought up by the defense. So I said that I would address it today, was the objection by the defense to the seating arrangement in the courtroom. And Ms. Mastalone, I don't know if you want to put anything on the record. I'm going to tell you straight up, so you can create your record, but I'm telling you right now, the way it's set up right now is the way it's going to be, based upon the limited room in this particular courtroom. We don't have a large area within the well to be able to move counsel table around. We have 4 people at defense counsel table right now as we speak. I don't know if there will ever be more than that or if this is what the 4 will be. So with that being said, we need the 2 tables that are set up. From my understanding, the state has 2 attorneys on this case, and they may have individuals that are seated with them to assist them with the trial. So there is no way to put this put tables on an angle. I'm not going to put attorneys and/or their people that are assisting them behind them in this particular case. I also want to leave enough room so during openings, summations, and for you to do your direct and cross with the way that this courtroom is set up, that I want to have sufficient room for all the parties to be able to stand up and do what they need to do, based on the fact where the witness stand is located and that the jurors are located across the room looking directly at the witness. This court does not find that there's any other place, another setup that can be done under these circumstances of this courtroom. I will also tell you, so if you want to address this also in your argument, is that this court does not intend on having that podium here for purposes of this trial. If you wanted it for your openings or summations, feel free. That's up to you. Otherwise, I will have a portable podium that you could put right on counsel table. So if you want to stand up and have it right in front of you, but then have all your other stuff that you may need for a particular witness, you'll have it right there. If you don't want that, then you won't need it. You won't have to have it. But based upon logistics, I can't even have a podium out here where you may be blocking the view of a particular juror as they're trying to analyze the evidence, especially in light of the arguments first thing this morning, wherein we're not going to allow note-taking so that people can pay attention to the actual witness. So Ms. Mastalone, with that being said, I want to give you the opportunity to place whatever positions that you want to place on the record, but at least out of fairness to you, want to let you know what I'm thinking.
Thank you, Judge. I mean, I think the court's explained, why we are where we are. It sounds like we have limited options. All I can say is I don't like it. I object that, but if, the court's going to rule how it rules, and if we have limited options, I understand the court's constrained as well. My only
the problem is
perhaps misunderstanding was I thought that the witness was going to be in that witness box. For the record, I'm pointing to the one that's like next to the
right
court.
Where my law clerk's located.
Right, where the law clerk is located, as opposed to only because this one just feels like our backs are to the jury more,
I understand.
As opposed to this one. So I don't know if that's something the court can reconsider or if that's already been considered.
So yes, it has been considered. I'll tell you why, that we were of the opinion that we have to leave the witnesses where it is. It was because from where Mr. Hinton is seated, my law clerk, is that I'm not sure Mr. Murray can actually even see Mr. Hinton in his full body from where he is, or he has to lean over. So I was worried about a sightline issue for each one of you, and I don't want that. And Mr. Caneiro has the right to be able to see that witness. So that's the reason why that we can't have the witness over here, and we had to have the witness right in front of you. But if you have any thoughts, feel free. Believe me, we tried. But if I ask the county to do one more thing for me, then, you know, I may get fired.
Yeah, I mean, I guess we can't move that one forward, right? It's
a fixed.
Okay.
Yeah.
Then, you know, I guess it is what it is, but, you know, so my objection, just, I would note it for the record that this is
Noted.
The objection is, I don't
Mr. Murray,
like
if you don't mind me, I don't mean to put you on the spot, but from
Really,
your
Mr.
vantage point, can you actually see my law clerk to be able to?
The top of his head, Judge, but if I moved over for purposes of cross, I could see the witness.
Right.
From the end of the council table.
Listen, if you all prefer that, my concern was for you, not for me. I can see. So if you want to do that, think about it and you let me know, because here's the thing. If we're going to do that, then we have a wiring issue, because that is wired. So we would have to, my division manager is in the back from IT, is probably losing his mind, but we would have to rewire it over to here so that we could do it. So that's up to you guys. I don't mind either way, but that's the way it's set up right now.
Judge, the problem though too is, as Your Honor indicated, that like Mr. Caneiro can't see.
That's the concern.
And yeah, so now that we're sitting here from our vantage point, it's an issue. So I think we are probably constrained to use the witness box that is diagonal from the bench and
I know, right? Yeah, it's like
across the courtroom from the jury.
There's
But
only
as
so many
far as the
options.
seating arrangement, I would just note my objection for the record.
I understand. Look, and you know, I can't tell you all what to do and how you do your directs and your cross and where you do them from. You can do them from council table. My suggestion also is you could do it from on the side next to where the jurors are and look straight across. If you want to get more of everyone focused on the witness and not on you and everything else, that's up to you. However you want to do it. The courtroom is yours for you to do your presentations. If you're going to do something that's extremely out of the ordinary, all I ask for you to do is let me know, so that if I have to deal with it, I'll deal with it. But other than that, again, I respect and understand what each side needs to do, and I want to give you the opportunity to do it. Believe me, based upon my experience, I've tried every other way to make this work. And if I thought that there was another way, I would do it. So, all right. All right. With that being said, let me see. Okay. I think we're coming to the end here. It's good for all of us. I did receive a proposed jury charge from the state dealing with the issue of life without parole because the defendant is eligible if convicted of any one of the first four counts of the indictment, that has the potential of life without parole. There was a proposed charge that was provided by the state. And I believe that the state has supplied it to the defense. The defense has had the opportunity to take a look at it. And are we in agreement or close to an agreement as it relates to the life without parole jury charge?
And I think we are either in agreement or very, very close to agreement.
Okay.
I don't have an issue.
I think we're in agreement, Judge. The state had supplied a proposed ad lib to the model charge, and I reviewed it, and then I changed it and submitted it to the state, and I conferred about it, and then we completed it and I submitted it to the court. I think we're all in agreement.
Okay, good. And I do have that. So for the record purposes, that is, we're all in agreement to that. Next. As it relates to pre-marked exhibits, we talked about pre-marking everything in this particular case.
Love that.
What I'm going to ask for is, once you pre-mark all of your exhibits, I'd like to have them uploaded into the share drive like you have shared other things for hearings. If you have any issues with that, I know you're going to be meeting with our division manager for IT. You guys can discuss that, but I'd like the pre-marked exhibits in advance, and I'm going to explain why. But I need them with the sticker on them already with the number that you're going to assign for each one of them. So here's the thing that during the course of the trial, you're going to be using these items. Some of these items may go up on the screen. Because the state will not be moving its evidence in until the end of the state's case, same with the defense. At that point in time, we would be in the position of then trying to remark all of those, and then we may be getting requests for those items. Nobody can get any of them unless I have had the opportunity to review it. So if I have them all in advance, and we can see certain items have already been marked, that they're probably going to be moved into evidence, we can at least have that process started, and we're not doing it all at once, because I don't want to create that kind of an issue.
I do appreciate how
you're talking about a list.
He's like, I want done before.
Well, not an actual.
No, the list.
The list, S1 through S200. I don't understand that.
I'm asking for, tell me if it's too much of an issue, that when you're going to mark S46, which is, say, a financial document that's 100 pages long.
Sure.
I want to upload it into SharePoint, because that we're going to need the final version of everything that's going to be used and to make copies of it. If it's too onerous, you can tell me that now, but we're trying to figure out something. We thought that would be easy for an upload, that somebody's marking them, somebody scans them in and uploads them into that particular drive, so then that we have them. If it's too difficult, you guys can tell me, but that's kind of what the thought process. If not, we're still going to need all of those exhibits at some point in time.
Can I ask for clarification? Your Honor had said something about moving the evidence at the end of the case, but I was under the impression that we were going to be moving in evidence through each witness. And so my concern.
What I'm saying is that a witness, you may ask them using certain documents or whatever it is. That's fine. The actual moving of those exhibits, I'm going to expect that the state's going to do it at the end of the state's case for all of its evidence, so that you can, if there's objections or issues or modifications, or because I won't know. If there's certain things that Mr. Decker wants to move in, and with a particular witness, and you have an objection to it, but he's going to use it on another witness later, I want it to be done at the end so it's clean.
But it can only be published to the jury if it's in evidence. So wouldn't he need to say to the witness, like, this is a photograph, and the witness says yes, and blah, blah, blah.
You guys are already going to have agreed on that, I am sure, of particular items. Yes, I understand the evidence rules, and I understand that if they go on the screen that they've already been moved into evidence. I assume that a lot of these are not going to be issues, because both sides are going to be using them.
Right,
But
so
there's
that's why I think
objections. You can't put things back in the box.
personally, I would prefer if we could just keep track by moving it into evidence through each witness as it's occurring, so that.
Can I see the attorneys in the back for a second?
Oh, what? Oh, well, that was the end of that.
This is a prepaid collect call from.
Oh, we don't need to hear you, Brooks. We're done with you. Okay, well, that wraps up that hearing. So that's giving us some insight as to what we can expect when this trial hopefully starts next week. And that's New Jersey versus Paul Caneiro. It's going to be 10 weeks, you guys, but I think it's going to be good. How do you guys feel watching the hearing? Are you guys excited for it? Interested? I am. I can tell you that. I do appreciate that this judge is very like, bloop, 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 bloop. I appreciate that a lot. I think there might be a lot of sidebars, but even then he seems very much like, I don't want to waste any time. And I appreciate that a lot. Not only like our time as viewers, but the jury time as well. Like he seems like he'd be a judge that would be like very annoyed by them interrupting and calling sidebars nonstop. So Buffy says, oh, I'm going to need something to put up with her. Oh boy, right? Now that hearing was in August, so a lot of those dates changed to right now here in January 2026, but I'm sure most of that just has stayed, put the entire time. So the trial will be Monday through Friday from 8:30 a.m. to 5:30 p.m. Oh, I'm sorry. Couch Court with Llama will be from 8:30 a.m. Eastern to 5:30 p.m. Eastern, Monday through Friday for the next possibly 10 weeks while we learn more about this case. And listen, it does seem like there's going to be some very hard days. Testimony. I'm sure I will cry quite a few times because I don't really do kid stuff very well. And it sounds pretty horrific what happened. So, but I'm excited. Our first trial of 2026, you guys. So we're either going to love him or hate him. I don't know. I don't know. I am disappointed, though, in the lack of accents already in court. I mean, it's Jersey. Of course, I did just get off of a Real Housewives of New Jersey bender a couple of weeks ago, which was amazing. So I was expecting some more Jersey, accents. Maybe we'll get them from the witnesses. I don't know. I hope so. Because we got them in Boston. We got them when we were in Mississippi and Kentucky. So we'll see. Did they mention approximate lunch times? No, they didn't. They didn't say anything about that. So, no, not the new season. They haven't even started filming it yet. I watched all of it from beginning to season 14 is what they ended on. I just ended it this past weekend. I've never watched The Real Housewives before, and I started with that one. I love it so much. Like, I was like, maybe I should just stop doing trial coverage and just cover The Real Housewives. I'm not going to do that. But we've seriously considered it. I don't know which one we're starting next because a group of us is watching them together. I think maybe Atlanta. I don't know. If you have a recommendation of which housewife series we should watch next, let us know in the comments. Oh my God, Stringer. Listen, that's the type of stuff is like usually not my TV interest. And one day I was like, I need to watch some trash TV to feel better about myself. And I knew some of my friends watched Housewives, and I was like, all right, fine, whatever. I'll give a couple episodes a try. I picked New Jersey because, it's New Jersey. So I knew it wasn't going to be boring. And oh boy, it was the best decision I ever made. I'll be honest. I'm obsessed. Yes, in bed listening, Liz. Well, listen, you guys, I'm going to get off here because I got a lot of editing I have to do because The Devil in the Bay, the series I recorded several months ago for our members, is starting to be released weekly. We have 4 episodes that have already come out. You can find the playlist on our YouTube channel, True Crime and White Time YouTube. We have 4. It's a really big project I took on. It means a lot. It's a case that's always stuck with me since I heard about it, well over a decade ago. So please go give that a like. Give the team some love in the comments because it was a group effort to put those episodes together. I got to go edit the next one after I get off here. So please go watch The Devil in the Bay. It's about the murders of the Rogers family when they were just on vacation in Florida. It's very haunting. It's a very haunting case. So go do that. Yes, if you haven't yet, follow us on Twitch right there, Couch Court with Llama. We only need 2 more followers to hit our goal. So, and I got to learn how Twitch works this weekend. But yeah, so I don't know if we'll be live Monday again. We'll find out tomorrow, though, after the end of the court day of what it'll be. So this weekend, you guys, go shopping, get all the coffee, get all your snacks, because we're going to need them for this upcoming trial. That's for sure. Well, I just want to say I had so much fun. It was so nice to see so many of you again in chat. I missed all your faces and all of the fun we always have. And I am looking forward to spending 2026 with you guys. Best community on the internet, if I do say so myself. Maybe I'm biased, but it's fine. But anyway, again, thank you all for joining us today. A little bit longer than we thought it was going to be, but that's okay. And hopefully I will see you all Monday morning at 8:30 a.m. if the jury's selected tomorrow. Otherwise, just make sure you're subscribed both to Twitch and to YouTube, because a notification will go out when we do go live so you don't miss opening statements, because I bet they're going to be long and I bet they're going to be full of a lot of stuff we don't know. So, all right, you all have a great rest of the day. And until next time, go forth and be amazing. Bye, guys.